Let's go on the record then with People State of Michigan versus Williams, file 241969 SM. Appearance.
Your Honor, Elizabeth Peterson on behalf of Williams. I don't believe that person is present in the courtroom today.
Mark Bonus, District Court Probation. I've not talked to her. I sent her an email this morning as a reminder. I guess I'd like to see what is going on with her. She just had to complete a class and she was supposed to be done, and I would dismiss this if she has completed it, but I can't verify that she actually completed it yet. So,
well, let me ask you what you'd prefer me to do. You want me to bounce this a week, or do you want me to issue a bench warrant?
well, let's set this out a week right now, and
right.
so I can make some contact with her.
All right, sounds good.
Thank you, Judge.
You're welcome.
Thank you, Judge.
You're welcome. All right, I believe that's it for Ms. Peterson's case. Oh, I'm sorry, you are with Ms. Green, right? No, you're not. Mr. McEwen
No,
is.
I think Ms. Kradowski indicated Mr. McEwen is. I did text Mr. McEwen, but I haven't heard back just to let him know he needs to.
No, he's in our waiting room now. So
yes, okay. All right, perfect.
All right, very good. We're all set then. You're all set then too, Ms. Peterson. Mr. Ledoux, you can either watch Mr. McEwen do his magic, or you can just leave with Ms. Peterson. It's up to you. Mr. McEwen, state your name for the record.
Thank you. Mike McEwen on behalf of the defendant, Ms. Green, Audrey Green. She's sitting to my right.
Okay. And then on behalf of probation.
Katie Kradowski, District Court Probation.
And then Ms. Green, would you state your name, please?
Audrey Green.
All right, very good. Mr. McEwen?
Your Honor, I did speak briefly with Ms. Kradowski this morning. She was kind enough to speak with me. I would like to enter a have my client enter a not guilty plea today to the probation violation. We would request that the matter be set out at least 30 days. In the interim, we had discussed some things that my client is going to accomplish to be able to provide to Ms. Kradowski before that hearing in approximately 30 days, and then discuss what her position will be on whether she believes that Ms. Green is appropriate to continue on probation after she's complied with some of these directives.
We'll enter a plea of not guilty to the probation violation. We'll set the matter for hearing in 30 days. But be warned, Mr. McEwen, I'll still be here.
Okay. You don't even know how to take that, but nothing.
I'm only poking. That's all.
I know. Thank you, sir. Have a good weekend.
Thank you.
You too. Are you hearing one of the motions, or
not for? I'm just going to wait a second.
are you applying? Are you here to apply for the magistrate's position? I would love to steal someone back from the prosecutor's office.
I still don't live here. I don't know how helpful I would be.
Well, yeah, then yeah, you're right. What's up?
Intern Malaika Fatima requesting to practice under.
Oh, whoa. Say that again.
Intern Malaika Fatima requesting to practice under
Oh.
MCR 8.120 under the supervision of the Deputy Chief Public Defender, Lauren Brown.
Okay. Have you been before me?
No, never.
I don't think you have. I need a spelling of your name. My recorder asked.
Malaika. First name, last name Fatima.
I told you. I did. I had it, sir. And where are you from?
I'm originally from Canada, but I'm in the dual JD program at Detroit Mercy and Windsor Law,
Canada, what part?
Toronto.
Toronto. One of my favorite cities. Where'd you go to undergrad?
I went to Toronto Metropolitan University.
Well, hearing no objection, permission to practice is granted.
Thank you, Your Honor. We do not believe that there is any conflict between this honorable court and our office. And if any conflict were to arise, we waive that conflict so that this honorable court can hear our matters.
The court, for its part, also does not believe that there is conflict. That is, if the court rules or the case is decided thereunder. To the extent a conflict may exist, given the waivers, the court will consent to hear the matters. The court does call the case People of the State of Michigan versus Anitra Comer.
APA Rachel McDuff for the people.
Good morning, Your Honor. Student Attorney Kara Rosengren requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Stephanie Cannon on behalf of Ms. Comer.
Permission to practice is granted.
Thank you so much, Your Honor.
Ms. Comer, can you state your name, please?
Anitra Comer.
All right, thank you. Yes, okay, and what are we doing on this?
Your Honor, we are requesting to adjourn for 2 weeks so that we can have a client consultation in person with Ms. Comer at the Women's Correctional Facility.
All right. Is 2 weeks going to be enough to work through the process out?
I believe so.
Think so? All right. 2 weeks notice what?
Thank you.
Probable cause conference in this matter will be adjourned. It's June 26, 2025, 9 a.m. Bond will continue. Thank you.
Thank you.
Court does call the case of the people versus Aiden Evans.
Ally Zend on behalf of the people, Your Honor.
Aiden.
Morning, Your Honor. Chris Eastup appearing on behalf and with Aiden Evans, who is present. Mr. Evans, you step up and state your name for the record.
My name is Aiden Evans.
I have a plea form in front of me. Is that what we're doing today?
It is, Your Honor.
The plea form indicates that the defendant will be pleading guilty to the charge of illegal entry, the 90-day offense. Upon the successful plea to that charge, count one would be dismissed, and that the parties agree to sentencing under HIDA. Of course, the court can't bind the sentencing judge. All right.
That's correct, Your Honor.
I haven't sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the true self you got.
Yes, sir.
State your name.
Aiden Jack Evans.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of illegal entry. That's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
Yes, sir.
All right. You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I plead guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Parole. Yeah.
No.
Oh, no.
That's bond.
Parole?
Bond.
Bond.
Okay.
That's how new he is.
Yes. All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Correct.
Yes.
Yes.
And because you believe that you're guilty of this offense?
Yes.
May 25th, 2025, at the location of 1043 North Main Street, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
I entered the premise without permission from the resident.
So you entered somebody's house,
Yes, Your Honor.
apartment, and you didn't have their permission to enter those premises,
Yes,
and you had no property interest or other thing in that property. Now, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense satisfied, ma'am.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at the district court probation. Sentencing will be
July 1st at 9 a.m. for Judge Fleischer.
July 1st, 2025, 9 a.m. before Judge Fleischer. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you.
Do we still having them check out at the window after plea, or do they just get their stuff? They make up their own?
I don't know. They should always check out according to Dan.
Thank you very much.
Really? Just do what she says. Court calls the case, People versus Terrell Green.
APA Richard McDuffie for the people. Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Green. Mr. Green, please state your name for the record.
Terrell Green. Thank you.
Hello. Thank you.
2 are arraignments. Got it. Okay. All right, Mr. Green? Yes. I have, you're here on one case. I have 2 other cases where you need to be arraigned on those cases. And so we'll go through that process if they put my paperwork in here. Starting first with the case 25F55605. In that case, sir, the complaint alleges that on or about May 3rd, 2024, at the location of 225 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan, that you did commit the offense of uttering and publishing. Do you understand the nature of that charge, sir?
Yes.
All right. That is a felony punishable by up to 14 years incarceration. You understand that, sir?
Yes.
All right. On the other matter, the case ending in 600. In that case, if I can find the complaint here. That complaint alleges that between the dates of April 10th, 2024 and April 11th, 2024, at the location of 423 East Duncan Street in Manchester, Washtenaw County, State of Michigan, that count 1 alleges that you did steal or retain without consent a financial transaction device. Do you understand the nature of that charge?
Yes.
That is a felony punishable by up to 4 years incarceration and a $5,000 fine plus court costs. Do you understand that?
Yes.
Count 2 alleges the offense of breaking and entering a vehicle with the intent to steal property less than $200. You understand that charge, sir?
Yes.
All right. There is a second or subsequent offense notice, which makes this a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property stolen. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. First question I have for you, sir, is do you wish to be represented by an attorney?
Yes.
All right. These are public defenders.
Your Honor, regarding both arraignments, we waive formal reading, stand mute to the charges. And I'm sorry.
Go ahead.
On all 3 cases, I'd request a pretrial date.
Probable cause conference.
I'm sorry, probable cause conference. Yes.
All right. You waive time limits.
Yes, Your Honor.
And you're asking for an adjournment on the other one.
Yes, he's going to be in Livingston, I believe, until September 30th.
Got it.
And we just want to review everything together and see what happens. Obviously, these are new cases.
All right. On these cases, I will adjourn the one case and set the probable cause conference for June 26, 2025 at 9 a.m. All right. And I'll get to the bond issue. Let's start with the Ann Arbor case first. Anything you want to say regarding the bond?
No, Your Honor, I just asked for a nominal bond. As I said, Mr. Green is going to be in Livingston County until the end of September.
Anything from the people?
Your Honor, on the, pardon me, on both of the cases, we requested a surety bond of $7,500. And with the reasons explained below, there's a no go-to request on this file for the DFCU financial branch at 25 Briarwood Circle. And I don't believe there's any no contact. That's the only other condition outside of the normal bond conditions on this file.
I'll indicate he's not to go to 225 Briarwood Circle. On that case, I will set his bond at a $5,000, 10% bond. I don't know that there's a necessity to have a cash or surety on this case. I will order standard conditions, including no assaultive behavior or possession of any weapons, no alcohol possession of no alcohol consumption or possession. Also, that applies for recreational marijuana and no illegal drug. Dated, I said 6/26.
Yes, sir.
All right. On the other matter.
On the other matter, there is a request for no contact with Susan Furda, F-U-R-D-A, as she is a victim in this case. I also requested a no go to, actually within a 1 mile radius of 423 East Duncan Street in Manchester, as this was a case of break-ins with multiple homes in that neighborhood.
How was her last name spelled?
F-U-R-D-A.
I have no objection to that, Your Honor.
Bond in this case will be set as a $5,000, 10% bond. It will indicate that there's to be no contact with Furda, and he's not to enter the township of Manchester. Anything else on that?
That no go to as well on that file?
He's not to enter the township of Manchester.
Oh, okay, I didn't hear you. Thank you.
Nothing else for me, Your Honor.
All right, thank you. Thank you, sir.
We'll be in touch, Mr. Green.
Court calls case People versus Mary Collins.
Hi.
Aye. Permission to practice is granted.
Good morning, Your Honor. Edward Drukas for Mary Collins this morning. I'm standing in for the attorney record of Kyle Burdell. I have a substitution form for the court that's signed. Not in the file, but will.
Very good.
And this morning I'm asking for an adjournment. I understand the discovery got sent over yesterday. Still need some time to go over that. I don't know if there's any outstanding discovery. I'd ask for an adjournment at the court's discretion.
Objection, probable cause conference will be adjourned to June 17th, 2025, 9 a.m. That's a Tuesday.
Okay, thank you.
Thank you. Court calls case People versus Ardeen Henderson.
Jennifer Douglas for the people.
Good morning, Your Honor. Ken Madadish on behalf of Ms. Henderson, who is appearing by Zoom. Ms. Henderson, can you please state your name for the record?
Arlene Henderson.
Thank you.
You're welcome.
Requesting an adjournment.
Yes, Your Honor, we are going to refer her to our AIM division and to continue plea negotiations with the prosecutor's office.
How long is she gonna be in Wayne County Jail? Does she know?
A while. I believe they're doing a competency report there. So it's gonna take a minute.
So-
we can adjourn it out
So there's a comp on her case there?
there. Yes, I'm debating whether I need to talk to
Council approach.
the seniors in our office.
Council approach.
Yeah.
Or you can keep talking. Council approach.
Oh, council approach.
I think that's an approach.
Told you to be quiet. What I do is talk a lot. Shut up and be quiet. Nobody got time for all that stuff. Y'all see me in court. Y'all want to play like two little kids. Y'all not getting no snack when we get back home. You hear me? Do you hear me too? Josiah, it's not funny. Don't say nothing else. They're gonna be back on here in a minute. I'm gonna give y'all some crackers. I'm gonna give you anything. You know? It's cold. I'm freezing.
Okay, on this case, what I will do is I'll adjourn the probable cause conference, understanding that I may get a request for a competency or forensic evaluation to coincide with the one in Wayne County, but I'll adjourn this to, we'll just do July 10th initially, and then we'll see where we are.
Thank you, Your Honor.
July 10th, 2025, 9 a.m. On continue.
Thank you.
Court calls case of the people versus Aaron Fromm.
Sherilyn Foster Tucker on behalf of Aaron Fromm.
Aaron Fromm?
And Your Honor, we're just requesting a brief adjournment to review discovery.
Probable cause conference will be June 17th, 2025, 9 a.m. That's Tuesday. Bond will continue.
Thank you, Your Honor.
Good day, sir. Okay. Court calls case of the people versus Winona Harvey. Chinaza.
We're going to grab it right now, Your Honor.
Really? Ma'am, state your name.
Winona Shell.
Thank you. Where is she? Somebody needs to get her in here or have somebody that can cover this case now. Thank you, Mr. Gaddy.
Morning, Judge Mike Gaddy on behalf of Ms. Harvey. You spoke with her?
Yes.
What's gonna
Said, that we gonna talk about, somebody that I hit.
Okay, did she tell you whether the case was gonna?
Yeah,
Did she say she was gonna adjourn it?
no.
Hold on. Yeah, I think this may be a referral.
Parental.
Yes, Your Honor, I'm trying to.
She told me that I'm here about a case about putting my hands on an officer at the correctional facility.
Okay.
That's what I'm here for today.
Yeah, Your Honor, we're going to refer this for competency. I'll prepare the competency referral and the, criminal responsibility referral forthwith.
Forensic evaluation is ordered. I'll set a competency hearing for 90.
August 28th.
90? Okay. Say it again.
August 28th.
August 28th, 2025.
Thank you.
9 a.m.
Thank you, Your Honor.
I have a court date August 28th,
Bond will
2025.
Yes,
What month is this? June?
this is June, yes.
It comes after June.
Well, I'll come visit you in the back, okay? July comes after June. Okay.
Court calls case People versus Charles Tingley.
Your Honor, good morning. Joe Simon on behalf of Mr. Tingley, who should be by Zoom.
Is he? Tingley?
I am Charles Tingley.
Okay, I'll need a camera.
It's just here.
All right, there he is. Okay.
Your Honor, I'm informed that the long-awaited contract with Detective Babbage in the county has been signed. And we are asking the court to grant our request for another adjournment. We're trying to be one of the first cases in line since we've been waiting, but I can't assure you of that. So
What's the anticipated time frame?
Well,
The only information I have is that I believe the contract has been signed, and so he's gonna start scheduling them.
Got it.
So maybe 3 weeks, if that's.
unfortunately, I'll be gone at that time. So, but
Beautiful. We'll set it then.
thank you, Your Honor. Very kind.
No, I want you around because you're around and Miss Landy's there. We learn things.
We do further our education. That is true.
I'm so full of nothing out. I am. It's a joyous time when you learn things.
It is.
So
That is true.
what date do you want?
Your Honor, could we possibly go to July 10?
Is there any objection from the people? Probable cause conference, July 10, 2025. 9 a.m. Bond will continue.
Thank you, Your Honor.
Yes. I think that's the quietest Landy's ever been. All right. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Molly Fox.
Ellen Dennis appearing on behalf of Molly Fox.
Oh. No. Your name?
Molly Fox.
All right, what are we doing?
Well, Your Honor, this is a PCC conference, and we've had many adjournments, but what I would like to see happen today is that the court would reinstate Ms. Fox's bond and let her get out. And I would say that Jacob Kennedy and I have had many discussions about resolution here, but we haven't really come to a conclusion. And he sent me the paperwork on the recovery court, which I discussed with Molly Fox. I went to visit her on Sunday and talked to her about it. And we went through some of the responsibilities and what would be expected of her if she could be accepted in such a court. I believe that she could do that, but only if she has strong family support. So I urged her to, what I would like is for her to get out so that she can talk to the family members, which are, in my opinion, their involvement and support is absolutely essential for her to be able to complete the recovery court program. The other matter is we have never really come to a conclusion as to what the plea would be if she were to go into the recovery court. So I would like to have an adjournment of the PCC, but I also would like to have her released again on bond so that she can do these things and come to some kind of conclusion.
Well,
I thought he was
stop using cocaine.
Well, of course she does. Absolutely. And she, she did complete the first 8 weeks successfully of the Dawn Farm program. She doesn't, that's the other thing. She doesn't know whether they would let her back into the program or They should actually be able to re-enroll.
Okay, so what do you want me to do with, you want this adjourned?
Well, yes, but I wanted to be adjourned with a release of her from custody and go back on the bond if possible. Because she's had
Okay,
kind of,
I don't negotiate that way, but that's okay. I don't know that I'll release her. I don't know what you want me to do.
well, as I did make out an adjournment paper.
Do people have a position on bond?
Yes, sir. In this case, involved a situation where the defendant was intoxicated. That's why she took the test. And then while she was on, I don't think that a release is appropriate without a rigid substance abuse treatment plan in place, which there is not.
Well, I'm informed that the Dawn Farm program would let her back in. I don't know for sure. I can't represent to the court that that's possible, but she seems to think it is. I don't know. And that's a pretty, she was attending AANA once or twice a week. She was doing group program, and she did that for 8 weeks successfully. And then, she had the incident where she used cocaine again. 2 incidents, sorry.
Yeah. Probably more because there's a lot of abnormal creatinine she was using. So the issue from the court standpoint is this. I am not going to release her or change her bond until there's something in place so that she's at least receiving some treatment or something along those lines or some program. It's not going to happen. Give you time to put that in place or to try to figure out what that's going to be. And I suggest that you talk with the prosecutor's office and try to work something out that is structured for this individual. So your motion for bond modification is denied. I will adjourn this matter to June 26, 2025, 9 a.m. The bond.
Your Honor, just for my own information, if I were able to determine that the Dawn program would let her back in or let her restart or whatever, would that suffice from the court's point of view?
here's what I'd suggest. If you were to confirm that type of, that there would be something in place for her treatment, I'd suggest that you get with the prosecutor's office, see if the two of you come to some type of agreement. Can't, you can file a motion, I'll hear it, or we'll hear it on the 26th. Okay,
Thank you, Your Honor.
thank you. Next case, People versus Christopher Gilmore.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Wendy Burnwell standing in for the attorney of record, Kareem Johnson.
Your name, sir?
Christopher Gilmore. Good morning, Your Honor.
Good morning. And you have no objection, Barnwell stepping in?
No, no, sir.
All right. All right, what are we doing?
Your Honor, Mr. Johnson has indicated that he received all discovery and he wishes to set exam dates on both cases. And do all that.
People have the witnesses available on the 17th.
My best, Your Honor.
You said June 17, Judge?
Yes, sir. Yes, ma'am.
When did
Preliminary examination in these matters in person, June 17th, 2025, 9 a.m. That is before Judge Moore.
Thanks today. If I can leave.
Your Honor, there's an ongoing discussion because my client wishes, Mr. Johnson's client wishes to have permission to leave the state. However, I'm indicating to him that the court would want that in writing. And the court would want
What's
defense
his
counsel.
purpose for leaving the state?
Right.
Your Honor, I'm about to turn a new leaf, Your Honor.
Pardon?
Can't just,
I'll-
the case has to be resolved.
All right.
You just want to leave the state?
Yes, I'm tired of getting in trouble. My summer, I don't want to spend my.
You don't like the great mittens of the north? Go ahead. You just want to leave the state while criminal charges are pending? Probably is not going to happen.
All right, thank you so much.
Yep, okay, great. That's glad we're,
Can't do it.
thank
I
you.
have a good one. Yep.
That was easy. Court calls the case, People versus Marvin Sullivan.
James Fifelsky appearing on behalf of Mr. Sullivan, who is approaching. Can you state your name for the judge, please?
Marvin Sullivan.
Your Honor, at this time, we will ask the court to set this for preliminary
All
examination.
discovery is complete.
Yes, Your Honor.
People have their witnesses available the 17th.
Is it any way possible to go 1 week to the 24th? And I will represent the court. I understand that Mr. Sullivan has a hearing in front of Judge Conlon on an extradition on the 25th. So I don't think this would be holding him any longer than he on this case than he would be otherwise.
I'll leave it to the court's discretion.
Preliminary examination in person, June 24th, 2025, 9 a.m. before Judge Fresh Hour. Bond continued.
Thank you, Your Honor.
Court does call the case of People versus Alexander, is it Bounds?
Your Honor, Student Attorney Kara Rosengren, under the supervision of APD Stephanie Cannon, on behalf of Mr. Bounds. Mr. Bounds, could you state your name for the court?
Alexander Bounds.
Your Honor, we're requesting that the court set a date for Mr. Bounds' preliminary exam.
All discovery is complete.
Yes.
People have their witnesses available the 17th. Preliminary examination in person, June 17th, 2025, 9 a.m. Actually, that's at 12 noon. That is before me.
Thank you, Your Honor.
Bond continued. Thank you, sir. That's in person.
Yes, sir.
Court does call the case of the people versus Elliot Kazan.
Ashley for the people.
Oh, you're still here.
I return, Your Honor.
Oh.
Joe
Picking up-
Stein.
To 8-2, the defendant is present in court on April 21st, 2025, where the defendant pled guilty to count 1, possession of cocaine, a felony of the 5th degree, in violation of revised code section 2925.11A with an attached forfeiture specification and renumbered count 2, operating a vehicle under the influence of alcohol, drug abuse, or a combination of them, misdemeanor of the 1st degree, in violation of revised code section 4511.19A1A. The defendant was found guilty. The court ordered a pre-sentence investigation and report and a drug and alcohol evaluation. The state has had the opportunity to review these reports and is prepared to proceed with sentencing. Thank you.
Ms. Corrigan.
Thank you so much, Your Honor. At this juncture, we would ask that the court adopt the agreed recommended sentence of a community control sanction. Your Honor, regarding the count 2, the operating the vehicle under the influence, he's obviously served approximately 30 days at this point. So I think that the mandatory jail time for that has been satisfied. Your Honor, we would ask that you take into account how forthcoming Mr. Maslenko was at the court. When we were before the court for the purposes of the plea, he let the court know he would be positive for cocaine. When he did report as directed to the adult probation department, he knew he was going to be taken into custody. He expected to be taken into custody the day we were here for the plea. He has sat in the county jail for approximately 30 days at this point. Your Honor, his new haircut is not for any political reasons. It's simply to maintain cleanliness in the jail. He thought it would be easier than having it in his face. Your Honor, he's been through a lot in those last 30 days. The toilet in his cell was clogged. Ultimately, they had to unclog it using their hands, not even a plunger. And I think that that experience in particular, if the court does believe in the concept of scared straight, scares Mr. Maslenko straight. He has absolutely no intention of finding himself in this situation moving forward. He has been clean during his time in the county jail. Your Honor, his longtime life partner is in the courtroom today too. She also has in the past struggled with addiction. However, since Mr. Maslenko's incarceration, she too has found herself working on her sobriety. I think together they would like to get and maintain sobriety and move forward as productive members of society. And I think with each other to lean on, this couple can so do. Your Honor, we would ask that you take all of that into account and impose a community control sanction. I would also like for the court to know that Mr. Maslenko is an arborist, and he does, well, he didn't have his boss's phone numbers memorized, so he hasn't been able to be in contact with them while in the county jail. He anticipates they knew he was coming in, they knew he was getting arrested, that he will be welcomed back, and I think it is probably their busy season. So I think he has gainful employment to return to. With all of that, Your Honor, thank you.
Thank you. All right, Mr. Maslenko, what do you want to tell me?
I learned a lot from this experience, Judge. I no longer want to play with my freedom. Drugs just isn't worth it. It's my first time incarcerated, and I definitely am not going to do anything to come back, and I apologize, Judge.
So how long have you been playing around with these drugs?
It's been a couple years, sir.
A couple? What do you mean a couple? Because it seems...
About four years.
Why did you start?
A bad breakup with my longtime high school sweetheart. I went downhill after that, but that's the last thing that I have to say that I'm completely over that situation. I was heartbroken, and now I found somebody else that's very good. It's pretty good.
So you've only been using drugs for a few years?
Yes, sir.
What kind of drugs?
Just cocaine.
What else?
I smoked pot a little bit, but it wasn't my drug of choice. My drug of choice was cocaine, but Judge.
Well, how long did you smoke pot?
Not very often, not very long. Here and there, I never really bought, I played with it when I was a child, maybe 13 years old.
For how long?
It's until I was incarcerated, but not like an
All right,
everyday.
so that marijuana is a drug, right?
I'm not, right now, I'm kind of uncertain because it.
Well, it is.
Okay.
It is, okay. It's a drug. There may have been a bad decision to legalize it, but it's still a drug.
Right.
Okay. So when your history indicates "24 years ago, a marijuana charge in Cleveland."
Yeah.
Domestic violence in Berea. Another, the same one. What was that one all about?
The domestic violence?
Yeah, in 2012.
Me and my kid's mom, we were both raging alcoholics, and she had jumped out her window while I was asleep on the couch and got in her car, got stuck in the neighbor's yard with the windows, with one of the cars with the headlights stay on. And the cops drove by in Olmsted Township, they went and investigated, and she said that I was beating her and she needed to get away. And then they arrested me.
Okay, so that was reduced to a disorderly conduct, which tells me that that's probably actually what happened, okay? Then we have this protection order issue in 21. What's that all about?
Well, after the breakup, I had moved to California. My dream was to climb the tallest trees in the world. Then my dad got sick with cancer and called me back. So when I came back, I stopped at a gas station, not knowing that she was there working at that gas station.
Who was there?
Kristen Christopherson.
Okay, when did she get a protection order against you?
I'm uncertain because I was in California. I'd moved.
So while you were gone, a protection order was issued?
Yes, sir.
When did you move to California?
I don't remember the exact date due to a lot of head injuries.
Okay. Head injuries from what?
I got run over by a car when I was really young. I was in a coma. I fell down some stairs and I had 20 staples. I've been hit by a couple of cars. I used to race dirt bikes and had a lot of concussions.
Okay. So what happened here on September 25th of last year?
My car, I had it on a trailer and it was at work, it was the work trailer, and we pulled the trailer from the street and made an immediate, it was on a corner street. We made a left, so that way I could pull my car off of the trailer and I could throw my four-ways on and block traffic, so that way we could load a machine onto the trailer without getting run over by a car.
How long had your car been on the trailer?
The car's on the trailer the whole day.
Why was it on the trailer?
Because I was gonna have the mechanic at the shop work on it.
Okay. So you were, whose truck was pulling the trailer?
It was Tree Service Now's truck.
Okay. So.
The mechanic worked for Tree Service Now.
All right. So so you were driving the truck?
No, I was picked up. The guy picked me up. I loaded the car up that day.
Where? Where did you load the car?
At Chagrin, where I live.
Okay. And then you were in the truck?
I was a passenger in the truck and they drove me to the job site because we had.
The job site was in Kirtland?
Yes, sir.
Okay. What happened at the job site?
Well, I pulled the car off of the trailer to block the traffic from running us over, you know. Then we loaded the machine on there and I made it.
Where was the machine?
The machine I was using inside the yard.
I know, but how did the machine get to the yard?
Well, we loaded it there. They brought it to the job site the previous day.
Okay.
So we had the trailer open, so I thought since it was open, he could just pick me up in the morning.
So you were using your car to block traffic?
Yeah, because I was gonna pull it into the client's driveway, so that way I could come back after I drop off the trailer,
Okay.
drop off the machine.
So what work were you doing that day?
Tree work,
And I know, but what exactly were you doing?
removing trees.
What were you doing specifically?
That's what I do.
I know that, but were you operating the machinery? Were you
Yes,
climbing the
yes,
tree
yes.
or what?
Yes, I
Tell
was
me
op-
what you were doing.
I was operating the machine.
Okay, what kind of machine was it?
It's a CMC 73. It's a lift
Okay.
that goes through a 36-inch gate.
All right. When did you do the cocaine that day?
I did the cocaine in the morning time.
What if you're a tree worker, then how do you do that when you're high?
The cocaine didn't really, from my perspective of the drug, it didn't really make me like high as alter my impaired. It more woke me up the way I do it, because I snorted it. I didn't do any, you know what I mean? 'Cause when I snorted it, it wakes you up, but that was from my perspective.
It wakes you up for how long?
About an hour.
And then what? What do you do after that?
If do some more, I guess.
Okay, so you gotta keep doing it to stay awake?
No.
Or keep alert?
No,
Or what?
it wasn't something to grasp a hold of to make things feel better from the breakup. It's how that was, and then I let it get out of control.
So you couldn't control it?
At that time, yes.
Well, at what time could you control it? Because you were still doing it.
Right, if the
I mean,
drug-
when you came to court, you tested positive. So when in advance of that court date did you last use it? How many days before you came here? Was it that day?
Yeah, it was that day.
Why would you do that? If you knew you were coming here, why would you do it?
It was, it's the sickness. It's
okay.
It was hard for me at that point in time to grasp control over it because I haven't went more than 24 hours from using it.
All right. Now, you weren't arrested that day, right?
Yes, I was.
You were arrested that day?
Yes, sir.
Okay. It doesn't seem like he was arrested that day. Because I have an April 21st positive.
I have a lot of head injuries. It's hard for me to.
Let me. I have a April 21 is the day we were here. You weren't arrested that day. Okay, hold on. Let me finish.
Okay.
Let me finish, and then I'll let you talk. A warrant went out on the 24th, 3 days later, because you tested positive. You came back here May 2nd for your interview. Were tested, and you tested positive again, right?
Yes, sir.
So that's the sequence here. So you just kept on using it after you were here until you got arrested on May 2nd, right?
Yes, sir.
Okay. How does it mix with the, go ahead.
I was just gonna say, I believe he was arrested and made bond to Judge Coronaccio, and then, because then I was involved almost immediately.
No, I'm just talking about when he was here, when he pled guilty.
Yes, that's correct.
You told me, or he said that he was gonna test positive, and I said, well, see what the test shows. He went over, tested, we didn't get the results instantly. We got the results, I put the warrant out 3 days later. He was out, he came back on May 2nd for the interview and tested again, he was positive again.
Yes.
So that's the sequence we're talking about here. So had you been using every day since you were here?
I don't understand the question.
The question is, on April 21st, you were here, you went over to probation, They had you do a urine sample, which tested positive, but you were still out. You weren't in jail.
Right.
Okay? From April 21st going forward to May 2nd, when you were here again, were you using cocaine every day?
Yes.
Okay. How does the use of alcohol affect you with the use of cocaine?
I don't drink alcohol.
Since when?
Since, it's been a while now.
Well, didn't you talk about way back on this domestic violence that turned into disorderly conduct, that you and the woman were
Yes.
both alcoholics?
Yeah, we were both raging alcoholics, yeah.
Okay, when did you stop using alcohol?
It was shortly after the breakup.
Which was when?
I can't remember, I can't recall the exact.
How many years ago? 10 years
Oh,
ago?
at least at least three.
3 years ago?
Yeah,
Okay, so you just stopped using, you stopped drinking.
due to heart issues. When I got run over by a car, it collapsed the artery coming off my heart that supplies the lower blood.
Okay,
flow.
how does the use of cocaine affect your heart issues?
It doesn't. I mean, it didn't. To me, it didn't, but it did end up in the hospital a few times, yes.
Because of what?
I did too much.
Okay, so that does affect your
Yeah.
body, okay? So you had the ability to just stop drinking, is what you're telling me,
Yes,
3
sir.
years ago. Okay. Why don't you have the ability to stop using cocaine? Because you don't, right?
I couldn't, I can't answer that question, sir.
Well, you can't, right?
Yeah.
You can't help yourself, right?
I can now.
Well, you
because-
can now because you've been in jail, so you have no choice.
Well, having the 30 days away from it definitely helps.
Uh-huh.
Definitely helped, let me tell you, because before, without having to take, a day off of it, I had no power, but having 30 days off of it and seeing exactly what's in store for me if I continue, like, that's definitely showing me the way.
Because you don't have any felonies before this, right?
No, sir.
Okay. All right. What mental health treatment have you had in the past?
I know I had a counseling through.
How long ago?
Had to have been a year, 2 years ago.
Okay. And you stopped doing it after that?
They cleared me, they told me I didn't have to come back anymore.
Where did you have that done?
Signature Health,
Okay. Was it in person or on the computer?
in person.
Okay. All right, anything else you want to tell me?
I apologize for my immaturity, and I thank you for even for this 30 days away from the drug. I was struggling, and I learned my lesson, Your Honor. You won't have a problem out of me.
Well, the lesson is not the issue, that's part of it, okay? But the question becomes, how do you not revert back to where you were? Because it's been a long battle for you between alcohol and cocaine, right? I mean, all you did was replace the alcohol with cocaine,
Right.
Okay. All right, Ms. Saronic?
Thank you, Your Honor. Pursuant to the plea agreement, the state did agree to join in a recommendation for community control sanctions. It is very apparent that the defendant does have a cocaine problem, and so I do believe that coupled with his lack of felony convictions warrants a community control sanction with drug and alcohol treatment. Thank you.
What's the mandatory fine on the OVI? Do you know offhand?
It is 375.
It's been 375 for like ever, but I think it might have just gone up. I know they
think it
just
did.
changed within the last like 8 weeks.
Oh, God.
So I'm sorry, Jeff.
If you give me one moment, I will look it
If
up.
it went up, arguably, and he picked this case up in September, it would still be 375 for him, I think.
Why don't you have a license right now?
Well, they took him because I didn't take the field sobriety test, Your Honor.
Is that the only reason you don't have a license?
Yes, sir. Yeah, I have a CDR license.
CDL?
Yeah.
He meant CDL.
Okay. And the license suspension is a 1 year, correct? 1 to 3?
Yes.
It is, yeah, the new fine is 565
Okay, but it was 375?
at the time, yes.
Okay. All right, I reviewed the pre-sentence report and the drug and alcohol evaluation. And the letter I got from your mother. Listen to Mr. and Ms. Lanka, listen to counsel. I considered all the provisions in 29, 29, 11, 12, and 13. I'll place you on community control for 3 years. With regard to count 1, you're going to serve 76 days in jail with credit for 36. The last 30 days you'll be in the jail treatment program. Complete it and follow the recommendations. You're to have no drugs or alcohol, and you'll be screened. You're to attend at least 4 AA or NA meetings a week and get a sponsor. You're to go to only 1 doctor and 1 dentist and 1 pharmacy. If you are prescribed any medication, you're to take your medication as prescribed and sign releases so probation can get your records. When your suspensions are up, you're going to get a valid driver's license, maintain full employment. I want you to get a mental health evaluation and follow recommendations and pay the costs and supervision fees. On count 2, 30 days in jail with credit for 30, $375 fine, a 1-year license suspension retroactive to September 25 of last year. So your suspension will be up in a few months, and you can begin getting the process of getting your license. Ms. Warren, any other terms with regard to the felony?
No, Your Honor.
Do you understand all the terms?
Yes, sir.
Any question about the terms?
No, sir.
Okay. If you don't comply with the terms, then the state will file a motion to terminate your community control. And if I find you violated, then you're looking at 12 months in prison. You understand that?
Yes, sir.
Okay. Now, I'm sending you to the jail treatment program because between alcohol and cocaine, you've got a long-standing, really uninterrupted problem that has been controlling you. And somebody with your medical condition that you described to me, I don't know how you made it this far doing that coke every day. And a lot of it, right? I don't know how you didn't fall out of a tree using that shit every day. So this is if what you're telling me is correct, then you want to get through this, and you can get through it, but at least have the opportunity to learn how to cope with this stuff, because doing coke every day wasn't doing it.
No.
All it did was put off the inevitable. Anything else, Ms. Horonic?
No, Your Honor, thank you.
Ms. Corrigan?
No, thank you so much, Judge.
Okay, we're adjourned.
All rise.
You seated. Celeste?
Thank you, Your Honor. We are present in State of Ohio versus Jacob O'Nusik, case number 25 CR 289. The defendant is in court represented by counsel. We are here today for purposes of a change of plea. It is my understanding the defendant is going to withdraw his formerly entered plea of not guilty and plead guilty to the following counts. Count 2, theft. Count 4, robbery. Count 5, kidnapping. However, it would be a felony of the 2nd degree because the victim was released in a safe place unharmed. Count 8, robbery, a felony of the 3rd degree, and count 9, kidnapping, also a felony of the 2nd degree for the same reason as count 5. In regards to sentencing, there is no agreement at this time.
All right. Watson?
Thank you, Your Honor. May it please the court, that's my understanding of this morning's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I believe full discovery has been provided. I've also had an opportunity to discuss this matter with my client. He has indicated that he is prepared to enter a change of plea as outlined by the prosecutor. He understands that by doing so, he will be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
Okay. All right, Mr. Onusik, how old are you?
31, sir.
How far did you go through school?
I've done some college.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
No, sir.
Did you get a copy of this indictment?
Yes, sir.
It's been represented to me that you're going to plead guilty to count 2, theft of felony 5, count 4, robbery of felony 3, count 5, kidnapping of felony 2, count 8, robbery of felony 3, and count 9, kidnapping of felony 2, and then the remaining charges would be dismissed at the time of sentencing. Is that your understanding?
Yes, sir.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, let me know, or if you want to talk to Mr. Watson, then let me know that, and I'll give you more time to talk to him. Do you understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, then I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of your rights?
No, sir.
Do you still want to plead guilty to these charges?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, sir.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I sentence you to prison?
Yes, sir.
And count 2, theft is a felony of the 5th degree. It carries a maximum prison sentence of 12 months and a maximum fine of $2,500. Do you understand that?
Yes, sir.
Your Honor, there was a typo on page 7.
Yeah,
Thank you.
I'm going to change that to 25. So that makes 15, 25, 40, 50, 52, 500 total. All right, count 4, robbery is a felony of the 3rd degree, carries a maximum prison sentence of 36 months and a maximum fine of $10,000. Do you understand that?
Yes, sir.
Count 5, kidnapping is a felony of the 2nd degree. It's what is referred to as a qualifying offense. That means the penalty range, I will give you one number, which will be the definite minimum, and then a second number, which will be the indefinite maximum, which is 50% of that definite minimum. Do you understand that?
Yes, sir.
All right, so on the maximum definite minimum for a kidnapping, felony 2 on the 5th count, the maximum on that definite minimum would be 8 years, and the indefinite maximum would be 12 years. Do you understand that?
Yes, sir.
Any questions about that?
No, sir.
All right, and the maximum penalty for the fine is $15,000. On count 8, robbery, it's a felony of the 3rd degree with a 36-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes, sir.
And count 9, kidnapping would be a maximum prison sentence of 8 years and a maximum fine of $15,000. Do you understand that?
Yes, sir.
Both of the kidnapping charges, the 5th count and the 9th count, there is a mandatory prison sentence. Do you understand that?
Yes, sir.
Any question about any of the penalties?
Your Honor, I don't believe the time is mandatory on the.
It's not?
No, it's not. It's
Okay.
just the qualifying offense.
Okay, all right. Any question about the penalties, Mr.
No,
Loomis?
sir.
Okay. Now, I could give you a consecutive sentence. That means one sentence after another for these separate offenses. If I did that, then the maximum definite term would be 23 years and the indefinite maximum 27 years. Do you understand that?
Yes, sir.
And the maximum fine would be $52,500. Do you understand that?
Yes, sir.
All right, do you understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes, sir.
Do you understand that upon your release from prison, you will be on post-release control for at least 18 months up to 3 years under the parole authority?
Yes, sir.
They will place conditions on you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation were a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
If that were the case, the maximum prison term for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand that at some point you would be eligible for judicial release?
Yes, sir.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
You understand at the time of sentencing, I do not have to follow the recommendation of either the prosecutor or your lawyer.
Yes, sir.
Have you had enough time to talk to Mr. Watson before pleading guilty today?
Yes, sir.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice he has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions?
No, sir.
Mr. Leslie, if the case went to trial, what would the evidence show?
The evidence would show that on March 7th, 2022, at approximately 1:02 p.m., the police department, in Richland County, state of Ohio, the police department was dispatched for a report at a robbery at the Check and Go. On this date, there was several employees present, Rachel Deskins and Elena Criswell. The defendant had been let into the store believing that he had an appointment. The defendant was wearing all black clothing with a black hat and had 2 face masks covering his mouth and chin. He began shouting at the victims to put their hands up. Rachel Deskins was able to push her panic button at this point. The defendant then leapt up from the floor on top of the desk and made them open their cash drawers. As customers were pulling at the doors to the business to enter, he had the victims get low to the ground. before he successfully fled out the back of the business with approximately $1,600. On this day, the victims did not see a weapon and there was no threats made. On April 25th, 2022, at approximately 3:08 p.m., there was another robbery that occurred at Advanced America in Medina County, Ohio. On this day, the victim let the defendant into the business, assuming he was there for a cash loan. At this time, the defendant followed him behind the cash counter. He demanded the victim get on his knees or he would blow his brains out. The defendant never brandished a gun, but had kept his hands in his jacket pocket, and the victim believed he did have one. The defendant then asked the victim to open the safe. There was a 15-minute time delay on the safe, and the defendant had the victim get back on his knees next to the safe while they waited the 15 minutes for the safe to open. The defendant eventually had the victim lay down on his belly and count to 200 before fleeing the scene. The defendant on this occasion stole approximately $990. On May 6th of 2022 at approximately 2:21 p.m. in Menor, Lake County, state of Ohio, Menor Police Department was dispatched again for a robbery at an Advanced America. On this day, the defendant entered the store wearing a mask, asking about a payday loan, although he didn't have any paperwork. The employee, Tracy Williams, immediately recognized him as the male that had robbed the Medina location. She had called the Ashtabula Advanced America in an attempt to pretend as if the computers were down to get the defendant to leave the store. The defendant kept asking her questions, and the victim told him to come back when the computers were back up and running. And at that point, the defendant had exited the store. He then stopped, turned around, put his foot in the door, and walked back to the counter. He told the victim to put her hands up and not to make any moves or he would shoot her in the face. The defendant also did not brandish a gun, but he had his hands in his hoodie as if he had a gun. The defendant walked around the counter and told her to go to the back room to get the safe. She advised that there was money was not in the safe, instead was in a gray box elsewhere in the store. The defendant then told her she had 10 seconds to put the money in the bag and started counting down from 10. He told her to go back up to the front money drawer and again told her she had 10 seconds to put money in the bag and started counting down from 10. He said not to look at him or he would kill her. The defendant told her then, after taking the money, to go to the back room, get on the floor, put her hands behind her head, and put her face to the floor. The defendant then exited the store and fled before police could be called. The victim ran out the front of the store to a neighboring business and had them contact the police. And on this occasion, the defendant stole approximately $1,879. Through collaborative efforts with the FBI, the Menor Police Department was able to identify the suspect through the use of CCTV from neighboring businesses and all of the robberies, cell tower mapping, and social media records. They identified the defendant as the suspect. Thank you.
Thank you. Mr. Watson, anything to add to the facts?
No, Your Honor.
All right, Mr. Onusik, did you hear what Ms. Alessi said, that the facts would show if this case went to a trial?
Yes, Your Honor.
And are those facts true?
Yes, sir.
All right, what is your plea to count 2, theft, a felony 5?
Guilty.
What is your plea to count 4, robbery, a felony 3?
Guilty.
What is your plea to count 5, kidnapping, a felony 2?
Guilty.
And what is your plea to count 8, robbery, a felony 3?
Guilty.
What is your plea to count 9, kidnapping, a felony 2?
Guilty.
Mr. Watson?
So it's the exact same form. I need you first. Sign right there. And then today is June 5th. Is it the 5th or 6th? June 5th. And then I need you to initial each one that the judge changed. So I did the same thing. So 2,500. So put your initials right there. Put your initials right there. And then I need you to sign right there.
I've witnessed the defendant and his attorney sign the written plea of guilty here in open court. And I believe all parties have also initialed page 7 where there was the typo as to the fine amount. May I approach?
Yeah. Mr. Onusik, is this your signature on the written plea of guilty?
Yes, sir.
And did you sign it voluntarily?
Yes, sir.
And do you want me to accept your written plea of guilty?
Yes, sir.
I'll accept the written plea of guilty. Defendant was present when Mr. Watson advised of all of his rights. In a knowing, intelligent, voluntary waiver, he understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary, I will accept his plea of guilty and find him guilty of count 2, theft, a felony 5, count 4, robbery, a felony 3, count 5, kidnapping, a felony 2, count 8, robbery, a felony 3, count 9, kidnapping, a felony 2. I'm going to refer this for a pre-sentence report and victim impact statements. Why don't we may change that to a day earlier, but I want you guys to check your schedule before we do that, so go see Maria. All right, now he's going to stay here in the next couple of weeks. He's not going back to the feds, right?
Correct, Your Honor.
All right, so we'll get that date. It's either going to be the 17th or the 18th, and we'll come back for sentencing. Okay. Anything else, Mr. Leshy?
No, Your Honor, thank you.
Mr. Watson?
Nothing further, Your Honor.
Okay.
All right.
Thank you, Your Honor. We are present in the state of Ohio versus David Wilkins, case number 25 CR 384. The defendant is in court represented by counsel Chuck Langmack. We are here today for purposes of a change of plea. It is my understanding the defendant is going to withdraw his formerly entered plea of not guilty and plead guilty to the state's offer. Count 1, failure to stop after an accident, a misdemeanor of the first degree. Count 3, failure to comply with an order or signal of a police officer, a felony of the third degree. And count 6, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the first degree. In regards to sentencing, there is a joint agreement for 24 months.
All right, Mr. Langmack.
That is accurate, Your Honor.
All right, Mr. Filkins, how old are you?
I'll be 67 next month, Your Honor.
How far did you go through school?
I got my GED.
Are you a U.S. citizen?
I am, yes, sir.
Are you able to read, write, and understand the English language?
I do.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, Your Honor.
Have you been diagnosed with or treated for any mental illness?
No, Your Honor.
Did you get a copy of this indictment?
Yes, Your Honor.
And those charges that Ms. Alessi recited, those are, you're pleading guilty to those?
Yes, Your Honor, I am.
All right, now before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand the question, or you want some more time to talk to Mr. Langmack, let me know and I'll give you more time. You understand that?
Yes, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
So if you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes, Your Honor.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes, Your Honor, I am.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Your Honor, I do.
If you plead guilty today, you do not have the right to appeal the guilty finding. Do you understand that?
I understand that, yes.
Do you have any questions about any of these rights?
No, Your Honor, I understand them all.
Do you still want to plead guilty to these charges?
I am guilty, Your Honor.
You understand by pleading guilty, you're fully admitting your guilt to the charges.
Yes, Your Honor, I do.
You understand by pleading guilty to these, to this felony that you're voluntarily giving up your freedom for whatever period of time that I sentence you to prison.
Yes, Your Honor.
All right, count one, failure to stop after an accident is a misdemeanor one. It carries a maximum jail sentence of 180 days and a maximum fine of $1,000. Do you understand that?
Yes, Your Honor, I do.
Count three, failure to comply with the order or signal of a police officer is a felony of the third degree. It carries an 18-month or a 36-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes, Your Honor.
Count six, OBI is a misdemeanor one. It carries a maximum jail term of 180 days and a maximum fine of $1,075. You understand that?
Yes, Your Honor.
In that charge, there's also a minimum jail sentence of 3 days, and the minimum fine is $375, and it's mandatory. Do you understand that?
Yes, Your Honor, I do.
All right. On count one, there's a potential license suspension of between 6 months and 3 years. Do you understand that?
Yes, Your
Is
Honor.
that mandatory or discretionary, you know?
I believe that is mandatory.
Okay, so a license suspension of at least 6 months up to 3 years. On count three, there's a mandatory license suspension between 1 year and 3 years. Do you understand that?
Yes, Your Honor.
And on count three, the failure to comply, there's a mandatory license suspension of at least 3 years up to your lifetime. Do you understand that?
Yes, Your Honor, I do.
Now, in addition, any prison sentence on count three, the failure to comply, it's mandatory that it be consecutive to your current sentence. Do you understand that?
Yes, Your Honor, I do.
Any question about any of the penalties?
No, Your Honor.
All right, do you understand that upon your release from prison, you'll be placed on post-release control for at least, is it 18 months to 3?
It's 1 year.
It's,
1 year to 3?
it depends if this
Up
court
on
determines it's an
mandatory.
offense of violence.
So 1 year to 3?
It's up to 2 years or a mandatory minimum one,
All
up
right,
to
so
3.
you'll be placed on post-release control for at least 1 year, up to 3 years under the parole authority. Understand that?
I do, yes.
And they will place conditions on you. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
I do, Your Honor.
If the violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
I do, yes.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, Your Honor.
Do you understand that at some point in this process that you would be eligible for judicial release?
Yes.
All right, now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No promises have been made, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I don't have to follow the recommendation of either the prosecutor or your lawyer at the time of sentencing?
I understand that, Your Honor.
Have you had enough time to talk with Mr. Langmack before pleading guilty today?
I have had time to talk to him, yes.
Has he discussed everything about your case and answered all of your questions?
Yes, Your Honor, he has.
Are you satisfied with the advice he has given you?
I am satisfied, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor, I am guilty. I just want to accept it and get on with my life.
All right, are you freely, knowingly, voluntarily, and freely entering your guilty plea?
Yes, Your Honor, I am.
All right. Hang on, not yet. You gotta listen instead of looking. All right, then, what is your plea to count one, failure to stop after an accident, a misdemeanor one?
I'm guilty, Your Honor.
What is your plea to count two, failure to comply with the order or signal of a police officer, a felony three?
I'm guilty, Your Honor.
What is your plea to count six, OVI, a misdemeanor one?
I am guilty.
Record reflect prior to your entry in the courtroom, I did have an opportunity to go over this document with Mr. Filkins, and he does have full knowledge and understanding of its contents.
Six, five.
Yes.
I've witnessed the defendant and his attorney sign their plea of guilty in open court, and I've signed it as well. May I approach?
All right, Mr. Filkins, is this your signature on the written plea of guilty?
It is, Your Honor.
And did you sign it voluntarily?
I signed it voluntarily, yes, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, Your Honor.
I'll accept the written plea of guilty. Defendant was present. Mr. Langmack advised of all of his rights. In a knowing, intelligent, voluntary waiver, he understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept the plea of guilty and find him guilty of failure to stop after an accident, count one, a misdemeanor one, count two, failure to comply, a felony three, count six, OVI, a misdemeanor one. I'm going to refer this case for victim impact statements. The sentencing will be June 11 at 9 a.m. Anything else, Ms. Alessi?
Yes, Your Honor, just briefly, I neglected to say this when I captioned the case. I just wanted to be clear for the record and to the court. Count one, I didn't say amended count one because the victim's names were not listed in the indictment, but count one is to include the victim of both the count one and count two as well. So there'd just be two victims there that are providing victim impact statements.
Okay. Anything else, Mr. Langmack?
Nothing else, Your Honor.
All right, we're adjourned.
All right. They can write a statement.
No. Okay. All right, call the deputy. See you later.
Hey, gentlemen, you written that guy? Yeah. Thanks. Who's the next guy?
Cedric.
Mr. Cedric. You got down too?
Yeah. Got a marathon this morning.
You got it going.
I know.
Hey, Paul. I had something to talk about.
Oh, Jesus.
See you, sir. Ms. Alessi?
Thank you, Your Honor. We're present in State of Ohio versus Richard Petrich, case number 25 CR 148. Defendant is in court, represented by John Fatika. We are here today for purposes of sentencing. The defendant previously pled guilty to count one, possession of cocaine and felony of the 5th degree in violation of Revised Code Section 2925.11 with the attached forfeiture specification. The court referred the defendant for a pre-sentence report and drug and alcohol evaluation and scheduled sentencing for today. Those reports have been completed and the state's prepared to proceed with sentencing.
Excuse me.
All right, Mr. Fatika.
Good morning, Your Honor. I've had an opportunity to review the PSR
in the drug and alcohol evaluation. I'd like to highlight the fact that Mr. Petrich has been at the Lake County Jail for 51 days. No institutional incidents have been reported during that time. He's a self-employed plumber. We acknowledge that he has a fairly lengthy history. 2 prior prison, the most recent in 1993. I don't believe he has any felonies since that 1993 conviction. We'd ask the court to consider community control sanctions here, conditioned on Mr. Petrich attending AA meetings, getting a home group and a sponsor.
I have a sponsor, no. I haven't seen him in a while, but.
Mr. Petrich, what do you want to tell me?
First of all, I want to apologize for my appearance right now. I've been trying, sir. I don't hang around with nobody like I used to. I don't know what I want to tell you. I want to tell you that I want this all to go away, but it's not going to happen. But I would do whatever's required of me, sir. I really needed to go to work. It's cost me a lot of money right now, a couple $1,000 probably. But I will do whatever's required of me, sir. I apologize for my behavior. I leave the alcohol alone for a while. I do sometimes, like, I binge drink, but, I can control it. I can. But, I'm going to just leave it alone for a little while, sir. I'm 55 years old. I don't know. I'm not a kid anymore. I apologize.
So what happened with this offense?
What happened?
Yep, back on January 27th.
Oh, I don't like saying it, but sometimes I use it for ED purpose too. Sometimes, I apologize for that.
No, I mean, what happened inside of Mark's?
I don't recall, actually.
Why not?
Because I was probably drinking too much.
Because you were blind drunk, right?
I was not blind. I was in a blackout, I assume.
Right.
I remember parts of it.
Where were you drinking that day?
On the street.
What do you mean on the street?
No, I wasn't. On a bus stop somewhere or something. I don't know.
It's freaking January. What are you doing outside of the bus stop drinking?
Traveling. I don't drive.
Traveling where?
I don't know. Wherever the bus takes me, I guess. Yeah.
Well, where were you going then?
I was going to go home. I was coming to Lake County. Well, it's because the bus changes from the RTA to the Lake Tran right there at Shoregate.
I thought you lived in Euclid.
I do live in Euclid. But my
Why
buddy's,
were you taking the RCA to the Lake Tran in Willow?
well, my buddy lives on, what's it, damn, I can't remember the street's name, right across from the park. Yeah, right, I'm going to visit some friends.
Which
That was
park?
You
Which
catch a
park?
three.
Which park?
The Menor Park, where the pool's at, right there, right past the cemetery.
That's Willoughby.
Yeah. I don't know exactly, sir. I mean, I don't know.
I wasn't asking exactly, I'm just asking
Okay.
questions, and you're
Yes.
giving me, I don't know what kind
I'm
of
just
answers.
babbling.
Okay. You don't have an alcohol problem?
Not necessarily. I was real bad during the early '90s and stuff like that. But I've grown out of that. I've grown up somewhat. You know what I mean? It's a lot of danger out there right now. You know what I mean? But I go to meetings still now. I just haven't been. I've been trying to do it by myself and without the
You
help.
got like a shitload of disorderly intox,
with the help of the
drug
Lord.
abuses. I mean,
It's
going back
ridiculous.
forever, and
It's
it's not changed, but you don't have a problem?
It's ridiculous.
Well, it seems to me you got all these things because you got a pretty bad drinking problem, don't you?
I have bad luck. I guess.
What?
Yes.
Look, on January 27, you created your own luck because you couldn't stop touching people.
Yes, sir.
I mean, So they had nothing to do with luck.
I know, yes, sir.
You got, what time of day was this? Do you remember?
After work,
Any idea how much you drank that day?
no. But I don't eat. No, it's not an excuse, but
Look,
I know, sir,
I mean, you told, what's her name back there? What's her name? Probation officer. Right there.
I don't know, we never formally
It ain't-
introduced
It ain't
her.
baby girl, right?
Huh?
It ain't baby girl. That ain't her name, is it?
I know, we never formally introduced each other.
All right, well, you kept calling her baby girl, I'm just wondering.
One
You
time.
thought that was her name?
And I didn't even fully say it
Okay. But you kept, I mean, you told her up and down you didn't have a problem with alcohol.
Sir, I don't say I don't have a problem, but it's not like when I was a kid going through all this.
It looks like it, because it's never stopped. I mean, there's a disorderly conduct on January 13th. This happens on January 27th. I mean, this is constant, your whole life. What are you doing with the cocaine?
Well, I was using it for some extracurricular activities. It's not.
Like what, playing baseball or what? And what are you talking about?
No, this is for the ladies, for the girls too.
How often were you using it?
I don't, because I barely get any.
Okay, but you told me you had it because you were gonna use it.
Yeah.
So my question is, how often do you use it?
Maybe a few times a year at that, I don't know.
Okay. You don't think I believe that, do you?
I don't think I believe it either.
All right.
Because
Well, you shouldn't tell me it if you don't believe it. I mean.
What do you mean? I don't know what
Listen,
you,
listen.
sir, I don't use it
You
like
clearly, you got caught with crack cocaine when you were blacked out drunk in January.
Yeah.
You've been drinking and drugging your whole life, okay? I think we had told you the drug and alcohol evaluator or Miss Henley that you hadn't used it like since '94, okay? Clearly, none of that's
I
true.
didn't say I didn't use it since '94.
When did you say that?
I said I haven't been in trouble since 1994, felony-wise. I mean, misdemeanors is, yes, I mean.
No big deal?
No, it is a very big deal. It's cost me a lot of money, and time too.
Then why do you keep doing it? If you can, you said you can stop drinking, you were gonna quit drinking for a while.
I have no excuse, sir.
I know, but if you could stop drinking, why don't you stop drinking?
I do.
When? When you're in jail? I mean, show me any extended period of time where you haven't gotten in trouble for drinking or drugs for the last 30 years or so. There isn't any.
Okay, well then you see all these cases, if you're saying that's true, okay, how many of them is there, 20? Okay, we'll say that, and then how many days of that? You wanna point out, that's what they do, people, you could do 99, you got 100 things to do, but if you do 99 things right, one thing you do wrong, boy, they point that out, but the 99 things I do right, it doesn't count. You do one thing you do wrong, just like what's going on right now, so I will promise you, I will follow the guidelines, whatever you ask me to do. Go to meetings, you know what I mean? I can't win. You know what I mean? Unless I try, you know?
That's right, you can't win unless you try.
Yes, sir.
Problem is you don't try.
Yes, I do.
No, you don't. There's no objective proof that you've tried.
Okay. So I do try.
Where do you live?
That was my father and my brother.
Well, your father don't want you living there, so what are you gonna do?
What do you mean you don't want me living there?
I'm just telling you, you don't want you living there.
I don't really want to live there either. But, you know, right now, I'm going through some changes, you know? But I had a trailer at the park, and they closed the park, they sold the whole land, and now I'm
Where?
at Euclid Beach.
Where's the trailer
They sold it.
They sold your trailer?
Yeah, they tore the whole property down. My brother owned it, and he got the money. I didn't own it, I was renting.
Was that, when did you live on Huntmere?
Just recently. Because the lady that, she bought a house, she lived in a trailer park too. I moved with her. She passed away just within the last 6 months, and her daughter now lives there. And my belongings are, some of my belongings are still there.
Where'd you get the cocaine from?
I don't know.
You don't know?
No, not
Just
really.
ended up in your pocket or what?
Yeah, no, it's somewhere in a bar, I don't know. I told you I was half in the bag, you know what I mean, in a trunk, whatever you're gonna call it.
Did you pay for it?
Yeah,
How much did you pay for it?
$30,
How do you know that?
because I know when I have my money.
But you don't know what bar you were in?
No, I was on, at 185th, probably at some, St. Joe's, right across the street from St. Joe's.
Is that where you usually got it?
Sir, no, I don't usually do it, sir.
Well, I mean, you said you got it 3 times. How did you know where to get it then?
Some of my buddies, they say, hey, I know where, but I don't mess with that stuff because they're selling stuff that'll kill you right now. And I don't do it, so I drink.
So how did you know it was in this cocaine?
Well, I didn't, sir. I
Then
don't.
why would you take it if you don't know what's in it, if it's killing people? All right, I can't take it anymore. Ms. Alessi?
Thank you, Your Honor. The state is recommending prison in this case. The defendant has demonstrated historically that he is not amenable to community control sanctions, and certainly is not amenable in this case. He's been convicted of vandalism, theft, aggravated menacing, assault, drug abuse, contempt of court on 6 occasions,
30 years.
slew of misdemeanor convictions, disorderly conduct, resisting, attempted theft, criminal trespass, open container, DUI, even though he contends today that he doesn't have a drinking problem. He's served 2 prior prison terms.
What'd you say to her?
Thanks.
Okay. Were you being sarcastic to her?
No, sir.
Okay.
No,
I think you were.
no, I wasn't.
All right, go ahead.
2 prior prison terms,
wasn't.
most recently being released in 1994, and he has 7 active misdemeanor warrants. Again, given his history, what's been said here today in court, his conduct here in court, I think he's demonstrated. He doesn't follow the law, he doesn't follow the orders of the court, and prison would be appropriate here. He has 51 days credit.
What were you thanking her for?
For helping me.
You don't seem like you want any help. You seem like you're bothered about having to do any of this stuff anyway.
No, sir. No, sir. I don't know. I thought I was okay. I am okay. I'm not.
You're not okay.
Sir, I am.
No, you're not. Go ahead, your turn. I mean, come on, look at your record. You can't stop drinking, and you can't stop doing drugs. And you're in Mark's blackout drunk, touching people in the store. You're okay?
No, I guess not.
All right, I've reviewed the pre-sentence report and the drug and alcohol evaluation. I've considered all the provisions in 29, 29, 11, 12, and 13. I'm going to place you on community control for 3 years.
Thank you, sir.
You're going to serve 101 days in jail with credit for 51. No, I'm sorry, 111 with credit for 51. The last 30 days, you're going to be in the jail treatment program. You're going to complete that and follow all recommendations. After you complete that, you're going to enter into either Lake House or Concord Pines, and you're going to follow all those recommendations. You're to have no drugs or alcohol, and you'll be screened.
What?
Did you hear what I said?
No.
Please shut up.
I don't
Be
know.
completely quiet. I'll send you a copy of the entry, okay? It's time to be quiet now.
And just let
Please,
my light pull
please,
away.
please, shut up.
Yes, sir.
You're going to attend at least 4 AA meetings a week and get a sponsor. You're going to get a valid driver's license. You're going to obtain and maintain full employment. No contact with Marks and Willowick. And you would pay the costs and supervision fees. Anything else, Ms. Henley?
Your Honor, would you like the defendant to take care of his warrants?
Where are they from?
Shaker.
I apologize.
There's Cleveland Heights, Shaker Heights.
In East Cleveland.
And East Cleveland, yeah, they're,
All right, then another provision, you clear all your warrants. And do you understand all the terms, Mr. Petrich?
Yes, sir.
Any questions? Any questions? Any questions?
No, I don't have any.
All right, if you don't comply with the terms, the state will file a motion to terminate your community control. If they find you violated, then I'll terminate you and you'll spend 12 months in prison. You understand that?
Yes, sir.
Anything else, Ms. Alessi?
Forfeiture of the cocaine, Your Honor.
Forfeited?
Thank you.
Mr. Fatika?
No, thank you, Your Honor.
This is Colin Brooks, 24-235, violation of community control, final hearing. Violation, failed to report to probation February 27 and March 13. You understand that charge?
Yes, Your Honor.
Also left the state of Ohio without permission. We're in Tennessee on March 18th. You understand that charge?
Yes, Your Honor.
Mr. Langmack?
Thank you, Your Honor. It's my understanding we intend to waive the final hearing and admit to the violations.
Is that what you want to do?
Yes, Your Honor.
What's your plea to those charges?
Yes, guilty, Your Honor.
I'll accept your guilty plea and find you guilty. Why didn't you report on February 27th?
Well, my probation officer, Derek, over there, he told me if I didn't report to aftercare, then I would have been violated.
Huh?
So he said if I didn't report to aftercare, I would have been violated.
If you reported to aftercare, you would
If I didn't go to aftercare for Lake Geauga, then I would have been violated. So I guess.
Wait a minute. When did you have aftercare?
I had aftercare on Monday and I was supposed to see him Thursday.
Okay. And so did you go to aftercare on Monday?
No, I did not.
Why not?
Because I totaled my car, I didn't have a ride. It's been a whole thing where I haven't been able to get a ride. I was living out in Garfield Heights, and I kind of guess I just got scared. I mean, I didn't want to be taken away from my son.
Why didn't you report on March 13th?
March 13th, because I got scared. I thought I was going to go to jail that day. I thought if I went, then he was going to arrest me and I was going to go to jail.
What were you doing in Tennessee on March 18th?
We went to a Cavaliers game in Memphis because on my way back home, I was going to go turn myself in.
Why did you go to a Cavaliers game in Memphis?
Because we wanted to do something that was nice for me. My girlfriend, she wanted me to pick what we were going to do. And I wanted to go do that, have a little fun time with my family, and then come back and turn myself in and take care of things. I really just didn't want to be taken away from my son and my family again.
And so where have you been the last 80 days?
In jail.
Is your son with you in jail?
No, he's not.
Okay, so this worked out really, really well.
I got scared, Your Honor. I should have done my mental health assessment.
Why didn't you do it? You were here over a year ago when I told you to do it. Why hadn't you done it yet?
I had a lot on my plate at the time. When I got out, before I got out, my big brother got killed. I lost my job, totaled my car. I kind of just felt like a dud in the moment.
Yet you went to Memphis to watch a Cavs game.
It was, my girlfriend paid for it. She just wanted me.
So what? You weren't supposed to be out of Ohio.
I know, Your Honor. I take full accountability for what I did. I'm sorry.
So once they picked you up in Memphis, where'd you go?
I went to Grayson County, Kentucky, in the federal holding facility.
And then where?
I went to Oklahoma.
And then where?
I went to Youngstown, Mahoning County.
And then where?
I'm here right now.
Okay.
In
How
Lake
how
County.
long did you bounce around a third of the United States?
It was about 2 months.
Because you felt like going to Memphis and you didn't want to go to jail.
I know it wasn't a good idea.
How were those 2 months for you?
Stressful and scary. I was on Con Air with all the federal inmates, and it was a real eye opener for me. It's definitely nothing I want to experience again. I was homesick the whole time. It was really a scary experience. So I just wanted to be back home with my son. And I know it was a little-
Why should I do that if you just show up whenever you want to show up?
Do what, Your Honor?
Why should I put you on probation again if you only show up when you want to show up?
Because now I know how it feels to be without my son. I didn't know it was going to hurt this bad to be without my son.
Well, that's nonsense. So, what's the reason you didn't do the mental health evaluation?
Because I was already doing meetings, which I was slacking on my meetings, and I was working, I was taking care of my son. I mean, she works too, so I mean, I don't want to leave her with my son all day by herself. She got up for work earlier than I did.
So why have you decided to put all this burden on her?
I'm saying because I was trying to help her, give her help with my kid, because he was in his newborn stages.
Right.
And I just wanted to be present as a
Who caused her all that burden?
I guess I did, Your Honor.
Yes, you did.
Yeah, I did. And I just wanted to build the bond with my son. I feel like I didn't have much time with my family like I wanted to. I mean, last year she was pregnant, so I don't feel like I was able to build the bond because I was in jail the whole time. But now that I'm in jail without him, I'm realizing that it's not where I want to be. I just want to be home. So, I mean, all I'm asking for is a second chance, and you have my word as a man. If I come back in front of your face, I'm pleased just asking for a second chance at this.
So where do you live?
I'm going to live with her, my girlfriend, and her mom.
What's her name?
My girlfriend?
Yeah.
Brenna.
Right. You haven't laid your hands on her lately, have you?
I have not.
Where do you work?
I was doing painting. I have a job waiting for me right now, actually, called 216 Painting. I was supposed to start back in March, but I had violated, and my boss texted my phone, which my girlfriend has, and said that when I get out, I have an opening as soon as I get out.
I mean, weren't you in enough trouble when you were a juvenile that you would have thought that you didn't want to continue that life and you'd have gotten your act together?
Yes, Your Honor, but I feel like every time I get in trouble, I come home a better man. I learn from my mistakes.
All right. So there's other ways to be a better man than getting into trouble and going away and coming home, isn't there? Why don't you try that for the alternative?
I'm sorry, Your Honor. I got dealt a hard hand in life, and it's still hard to make dues with what
Well,
I
yeah,
have.
that's probably the reason I told you to get a mental health evaluation 15 months ago.
I know.
But you didn't do it.
I had a lot on my plate, Your Honor. I'm sorry.
You've told me that 3 times now. You have a lot on your plate because you're the one that put everything on your plate. Nobody else. Right?
Yes, Your Honor.
Okay? So you're 20 years old now.
Yes, Your Honor.
At what point do you start acting like you're 20 years old and not 14 years old?
The point that starts now.
Okay? You can't just pick up and go to Memphis whenever you want.
I know.
Okay? Now, the reason you can't do that is because you committed a crime and you're on probation, okay? So why don't you figure out something here? You already know for the last however many years, when you first got in trouble in juvenile, okay? For the last 7 years, you've been involved with various courts, across the street and over here. And you got, Derek's been following you around since you were a juvenile, telling you what you can do and when you can do it. Do you like that?
No, I do not, Your
Okay,
Honor.
then why don't you stop putting yourself in a position where you got people telling you where you can go, what you can, where you can't go, what you can do, what you can't do, when you got to report, when you don't have to report. Aren't you sick of living by other people's rules?
I'm very sick of it, Your Honor.
The alternative is to live by society's rules. But until you finish sufficiently living by other people's rules, you can't live by society's rules.
Yes, Your Honor.
See? So the lesson is get your shit together, or else you'll be sitting here when you're 30 and 40. There was just a guy here a couple hours ago who's 67.
I don't want that for myself.
Well, you control that.
I control it, Your Honor.
I don't control that.
Yes, Your Honor.
Mr. Langmack?
Thank you, Mayor. As Mr. Brooks said, I think that nearly 2 months trip in the federal system was a bit of an eye-opener, as it would be to anybody. It sees the raw seriousness of the path that you choose to go down or you choose to go the other way. I think he's going to choose the other way, Your Honor.
Well, I don't know.
I
would have thought that. I would have thought that as of last May.
That is our hope right now. And additionally, you'll have to excuse the head covering on that. He was trying to cut his hair last night and did a bit of a botched job, so it's no disrespect to the court. So we're asking for another chance for Mr. Brooks. Thank you.
All right, I've gone back and looked at the pre-sentence report, listened to Mr. Brooks. Mr. Langmack, you're going to stay on community control. You're going to serve 85 days with credit for 80. And you're to comply with all the things I told you to do last May 10th that you haven't yet done, which isn't a whole lot.
I know. I'll be looking to do more when I get out, Your Honor.
Well, here's my advice to you. Stop talking about doing things and do things.
Do it easier than here.
Because they don't get done if you talk about them. They get done if you do them.
Like I said, Your Honor, you have my word as a man.
Well, don't talk to me. Show me. Mr. Clement, anything else?
Except for competency.
It's just on the bond. In July.
It's here on the bond, on the bond, right? And you know nothing about those, I take it.
That's correct, Your Honor.
Is there a report? Oh,
That's all.
Council.
What?
Hearings. Defendant is in custody on this case, I think, as well as others. He's awaiting a review hearing, which is set for July 22nd, 2025. Well, he wouldn't have been in. I think at this point, he's being held on this alleged bond violation, because otherwise it wouldn't have occurred that way. So at this point, what I will do is I'll continue the defendant's bond as being revoked for the violation pending a hearing on this. There's a report that needs to be prepared, as well as I have shown counsel the preliminary results, I guess, of the bond violation, which is possession of a weapon. So I'll set a bond violation hearing on this matter for June 26, 2025 at 3 p.m.
Thank you, Your Honor.
All right, thank you. Court calls case People versus Anton Brooks.
Good morning, Your Honor. Wendy Barnwell, standing in for the attorney of record, Mr. Kareem Johnson, on behalf of Mr. Brooks.
Thank you, sir.
Anton Brooks.
You have any Barnwell speaking? All right, what are we doing?
Your Honor, Mr. Johnson needs an in-person PCC on June 26th. He told me that's when he's available. He said, however, because he doesn't have all the discovery.
Oh, hold on. So he doesn't have the discovery. The 26th, he's just asking for an adjournment of the probable cause
PCC,
conference.
Judge.
Okay, thank you. Probable cause conference will be then adjourned on January 26, 2025, 9 a.m.
Thank you, Judge.
Bond continued. Thank you. Court does call the case People versus Robert Brascom.
Marie Canhouse is the prosecuting attorney on behalf of the people.
Good morning. This is Public Defender Lauren Perny on behalf of Mr. Branscombe. Mr. Branscombe, please state your name for the record.
Robert Branscombe.
Your Honor, we're asking for an exam date, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 17th.
I believe so, Your Honor.
Preliminary examination in person, June 17th, 2025 at
12 p.m. for Judge Simpson.
12 p.m. That's before me.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continued.
All right, thank you.
Thank you. Court does call the case People versus Anthony Alfaro Siquejas.
If you're Richmond, different.
Honor, Assistant Public Defender Nicholas Bukovich on behalf of Mr. Alfredo Correjas.
There we go. They had to go home. Seriously? Not really.
You can say your name for the record.
Anthony Alfaro, KS.
Got it. All right.
At this time, Your Honor, I'll be asking for a brief adjournment. He has another probable cause conference date scheduled with you next week on a new matter that is the basis for the alleged bond violation. So we are asking for the adjournment to be able to track those cases together.
He has a what?
A probable cause conference with you on June 12th.
On June 12th.
So next week. So we're just asking for that brief adjournment so the cases can track together.
And that case is what result.
Is what I believe is the alleged bond violation.
That's what I was trying to follow with what you indicated. So
Yes,
we'll deal with that bond violation. I'll grant the adjournment.
Thank you, Your Honor.
I'll adjourn this probable cause conference, June 12th, 2025, 9 a.m. bond continue.
Thank you, Your Honor.
Thank you. Jabakovich, that went much better for you than last week.
It did.
Maybe it can continue.
That's the goal, Your Honor.
Because when you came up, I got scared. I just didn't know. Court calls the case, People versus London Daughter.
Andrew Childers appearing on behalf of the people, Your Honor.
Judge on behalf of Mr. Daughtery.
London Daughter.
Okay. It's two cases. What are you looking to do?
Your Honor, we are going to be adjourning. I believe we don't have discovery on one of the cases, so we're waiting to receive that from the prosecutor's office.
And I'm presuming that's on its way.
I believe it's the 1318, or one of the legal assistants or paralegals in our office emailed, I believe Tuesday, and then they looped you in and said, have you guys requested it? It's from a couple of years back, but we don't have discovery on one of them.
All right. Well, what I'll do is I'll adjourn probable cause conference June 26, 2025, 9 a.m. Let you guys try to get that cleared up. I see that the one is a 22 case, so sure they'll be able to find it. But all right.
Thank you.
We'll continue. Thank you, sir.
Thank you. Okay.
Court calls case People versus Jerome Burns.
Morning, Your Honor. And Assistant Prosecuting Attorney Babbitt. And Assistant Public Defender Chinazi Kyriak and really, Your Honor, on behalf of Mr. Jerome Burns.
Nice of you to show up. Just thought I'd throw that out there.
I figured it was coming your way.
Mr. Burns, state your name for the record, please.
Jerome Burns. Thank you, sir. All right, what are we doing?
So, Your Honor, we are here for two matters today. I think we're doing a sentencing on the bond violation for Mr. Burns, as well as the probable cause conference. In regards to the probable cause conference, Judge, we are asking that this matter be respectfully set for preliminary examination.
You have all of the discovery.
To my knowledge, Judge, yes, we do.
We'll have the witnesses available to 7.
We'll do our best here.
All right, why don't I do this? I'll set preliminary examination June 17th, 2009, 9 a.m. Or, well, why don't I do it this way? I'm going to set this one at 12 p.m. for me since I just plea on the other day. And I'll adjourn the sentencing on his bond violation to that same day.
Okay.
Thank you.
So, Bond will continue. Court does call the case People versus Tequila. Evans, Guy. What?
She should be on Zoom.
Tequila's on Zoom? Is she here?
Oh, okay.
I don't see her name. Oh, there she is. Tequila, stop coming down.
She wished she could have.
Sure. Tequila, can you state your name?
Tequila Evans Guy.
Good morning.
Good morning.
All right. What are we doing?
So, Your Honor, when we were here last time, I incorrectly filled out the plea form where I said that I was adding count 2 and dismissing count 1. And I meant to put I was adding count 3 and dismissing count 1 and 2. So that is why you're here today.
It's also my bad because I didn't notice that on the plea form. So it's count 1 and 2 that are getting dismissed.
Got it. We're coming back just to correct the record. All right. What I will do then is I will sign sort of dismissing counts 1 and 2, accepting the defendant's plea to count 3, and then set the sentencing date. I'll set the sentencing date 7/10/25 at 10 a.m. before Judge Washington. And what I will do is I'm accepting the plea to count 3, non-protunct to May 22nd.
Do we need to turn in the form or not?
Yes, why don't you?
We don't need the advice of rights again, right?
You don't need that.
Okay. Thank you, Your Honor. Thank you, John.
Thank you. That should clarify everything. Court calls case People versus Curtis Damon.
Good morning, Your Honor. Lord Yaggi, Assistant Public Defender, with and on behalf of Mr. Damon.
Good morning, Ms. Yaggi.
Good morning. Mr. Damon, could you state your name for the court?
Yes, Curtis Mitchell Damon.
Your Honor, I did fill out a green sheet. However, I am asking if this court would consider allowing Mr. Damon to be released to treatment. He is
To inpatient treatment?
to inpatient.
I'm going to have no objection to any order allowing somebody to be released to treatment.
Okay, thank you, Your Honor. I think that will help immensely, and I know Mr. Damon is really serious about that.
All right.
Oh, and we would request an adjournment of the probable cause conference for him to get into treatment. I think that will help discussions with the prosecution about how to
Do
resolve.
they have a timing to try to get him there, or how's?
I don't have any specific update as to timing.
Well, why don't I do this, then I'll adjourn the probable cause conference to June 26, 2025, 9 a.m.
Thank you.
See what progress they make regarding.
Thank you, Your Honor.
Thank you.
So a quick question regarding bond, because Mr. Damon's tether, I mean, they closed his file essentially because he absconded as far as his frame is concerned. What would be the status of that order? Would the court wait to see if?
They closed it. They closed out his tether.
Yeah, we have a report from May 13th, I believe, where they had lost contact with Mr. Damon. He last reported for a scram download April 29th. And so where that particular tether might be located and whether we would need a new order, depending on what happens with his treatment. He said he still has.
And thank you, Ms. McDuffie, for bringing that up, because I actually, in the proposed order I drafted, I did put in all prior bond conditions remain in full force and effect. I didn't mention anything about the tether, so.
Okay, I'm just looking at it. That was a GPS tether.
Correct.
No, alcohol.
It was a scram tether?
Yes.
Yep.
Okay.
Yeah.
So what I'm gonna do is I'll just add it, I'm adding a sentence to the order I signed. He can be released to inpatient treatment program once a bed becomes available with a scram tether prior to release. Okay, so I'll add that, and I will also sign a new order for a scram tether. So that way, if a bed becomes available, he gets a scram tether. Okay,
Thank you, Your Honor.
and I'll set it for June 26, 2025, and bond continue. Thank you.
Thank you. Thank you.
Court calls case people versus round two Francis.
Dr. Lonnie, people.
Suze?
Oh,
Seriously? Okay.
Oh, it's Francis. Oh, Assistant Public Defender. I thought they were bringing up my other client, Judge. Assistant Public Defender, Chinazi Carey, I can really, on behalf of Mr. Brown, to Francis, Judge. Can we approach?
Durant to Francis.
Thank you.
Of Ms. Siobhan Benson. Hey, say your name for the record. My name is Siobhan Benson.
Don't find it now.
Get right behind you.
All right.
Your Honor, today is a time and date set.
Your name, ma'am?
Oh, my name is Siobhan Benson.
Thank you. All right, yes, go ahead.
Today is the time and date set for a competency hearing in all matters. And the people are in receipt of a report from Center for Forensic Psychiatry dated May 15th, 2027, authored by Candace Shield, PhD. And we would stipulate to the entry of that report and ask that the court make a finding based on that.
Any other evidence for the defense?
I apologize, Your Honor. You asked if there was, Your Honor, we have had an opportunity to review the report as well. We are going to stipulate to the findings in the report, and as per the probable cause conference, Judge, we're asking for an adjournment as we continue our investigation.
All right. For the purposes of the competency, the defendant, based upon the review of the report, the defendant is competent, will be found competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against her, of the charges against her, and can rationally assist in her defense. Therefore, the defendant is deemed competent. I will set a probable cause conference then. Would the 26th work for you?
We will make it work, Judge.
June 26th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue.
I also want to expose these people because they're lying on me. I'm not no demon. I'm not no monster. These people were hurting my daughter. They were sexually assaulting my child.
You'll have an opportunity.
It's too much. I'm not no demon. They hurt my baby and they're hiding this. They're covering it up. The state of Michigan is hiding and covering this up. They hurt my child. And I'm gonna
Thank you. And Ms. McNurley, I'll need additional orders on this.
The findings, right?
The findings, yes. Court does call the case of People versus Levine Cava.
Assistant Public Defender Natalie Pate on behalf of Mr. Kaba, who may be present via Zoom.
See him. You got a Cava?
Yeah, I have one unnamed individual client.
Lamine Cava? No, I don't have them.
Your Honor, I do not have an explanation for his failure to appear. I was unsuccessful in reaching him between the last probable cause conference and today's date. I did also make attempts to contact his mother and left a voicemail with her as well as provided her with the Zoom information. I have no further explanation for his failure to appear and for the record would respectfully request an adjournment of this probable cause conference.
Bench warrant will issue for defendant's failure. Bond is set in the amount of $10,000 cash security. That warrant will issue.
Oh.
Does call the case People versus Vincent Dunlap.
Some Public Defender Jay Bellinger, on behalf of Mr. Dunlap. Miss, can you please state your name for the record?
Vincent Dunlap.
Thank you. So what are we doing?
Your Honor, we are just asking to set this for a preliminary examination today.
Discovery is complete.
Discovery is complete to the best of my knowledge.
Are the witnesses available the 17th? All right. Preliminary examination in person, June 17th, 2025, 9 a.m. That's before Judge Moore. Bond continues.
I'll still be here, okay? 17th. All right. All right. Thank you.
Court calls case of the People versus Elia Keys.
Natalie said on behalf of the people, Your Honor.
Assistant Public Defender Nicholas Bukovich on behalf of Ms. Keys, who should be appearing via Zoom.
State your name, please.
Keys.
Thank you. All right, what have you done?
At this time, Your Honor, we'll be setting this matter for preliminary exam. To my knowledge, all discovery is complete. And when appropriate, may I briefly address bond?
People have their witnesses available the 17th.
We'll do our best, Your Honor.
Preliminary examination in person, June 17th, 2025. 12 noon. That's before me. Yes, that's the bond.
As to bond, Your Honor, Ms. Keys did have a no-go to an address located on East Michigan Ave. It is an address that she does have a lease at. The purpose for that no-go to was because the complaining witness was moving out of that residence at that time. From my conversation with APA Zenda, it's been indicated to me that complaining witness now has fully moved out, has her animals, has no reason to return that address. Ms. Keys is the only person on that lease, so I'll be asking that that no-go to order be lifted so she can return to that apartment.
Response.
Your Honor, we would have no objection. We did get confirmation that she has been out of the address for some time, so she would not be residing there or returning.
So I will delete the no-go to provision. Okay. Very good.
Thank you, Your Honor.
Thank you.
Otherwise, bond will continue with its conditions.
Thank you.
Court does call the case People versus Demario Farrell.
Alexander on behalf of the people, Your Honor.
Morning, Your Honor. Mike, I'm public defender on behalf of Mr. Farrell. State your name, Mr. Farrell. Farrell. Your Honor, at this time, we'd ask the court to set this matter for preliminary exam.
All right. Discovery simply.
Yes, Your Honor.
People have their witnesses available the 17th.
We'll do our best, Your Honor.
Judge, if I could be heard on bond.
Yes, preliminary examination in person will be set June 17th, 2025, 9 a.m. That is before Judge Moore. Yes.
Judge, Mr. Farrell is here. Obviously, he's in custody. We're asking that the court maybe consider reducing his bond and giving him a GPS tether. He does have a local address. There's an address that I can give to the court over in Ypsilanti that where his father and grandmother reside, and he may reside there as well. He reports also he did obtain a job in Wixom, and it is a full-time job. He reports that he has been in contact with his boss there, and the job is open for at least for the current period. We'd ask the court that the court give him an opportunity to reside outside the jail, either by reducing his bond to a postable number or a personal bond with the GPS tether, and any testing requirements and no go-to requirements that the court deems fit to ensure both the safety of the public and his appearance. And the address on Kirk Street in Ipsy is not an address where the complaining witness resides.
So the address you were referring to is the Kirk Street address.
Yes, Judge.
All right, thank you.
Your Honor, I'm going to object to modification of bond. This case is a reauthorization of a misdemeanor matter before Your Honor.
Sure.
I have concerns, given that in that case, which he failed to appear back in 2023, did not come back into contact with law enforcement until May of this year, and he was picked up. And at the time that he failed to appear, he had a violation of bond for leaving the state, and also for contacting the victim after he had been released. I had concerns, given that there were concerns of previous contact, and that he failed to appear for over a year and had left the state. So I would ask that bond remain the same in this case, Your Honor.
Your Honor, Mr. Farrell is well aware of the importance of this matter, and I would note that he's now charged with a felony. It's a brand new case. This case has been kicking around for I don't know how long. I don't know why it was never charged as a felony back then, but it is now. I'd ask the court for a personal bond or a reduction.
That's the state.
That is my end. That's what I'm informed by the people.
Motion for bond reduction or modification is denied. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Alexander Cronin.
And Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Cronin. Mr. Cronin, could you state your name for the court?
Good morning, Your Honor. My name is Alexander Cronin. How are you, sir?
Good. Thank you.
And Your Honor, I apologize. I was just emailing about this case. It is going to be a request for an adjournment due to some discovery, as well as continuing discussions with the people about potential resolution.
Any objection from the council? When are we? June 26, 2025, 9/8. Bond continue.
Thank you, Your Honor.
That's called the case of the People versus Alua Gillis.
Alexander on behalf of the people, Your Honor.
Assistant Public Defender Jay Ballinger on behalf of Ms. Gillis, who approaches. Gillis, can you please state your name for the record?
Alua Gillis.
Request a forensic evaluation.
We are, Your Honor.
Forensic evaluation will be ordered. I'll set a competency hearing for August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Shelby Lawson.
Your Honor, Student Attorney Kara Rosengren, under the supervision of APD Stephanie Cannon, on behalf of Ms. Lawson. Ms. Lawson, could you state your name for the court?
Shelby Lawson.
Really supervising. No, I'm just kidding. Just thought I'd ask. Go ahead.
Your Honor, we're going to be requesting to adjourn Ms. Lawson's case. We're still awaiting some discovery.
Without objection, probable cause conference will be adjourned June 26, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Case People versus Stephen Johnston.
AP Richard McDonough for the people.
Or Yagi, Assistant Public Defender, with and on behalf of Mr. Johnston. Your Honor, may we approach on this matter?
Yes.
As I mentioned, to the priority of his, treatment, acknowledges, the issues he has with substance use, and he is eager to get treatment. I know Mr. Johnson is not happy about my request for an adjournment of the PCC, but I think it's important, because I do think there is some additional discovery that we should see before he makes a decision whether or not to waive, his exams.
Adjourned probable cause conference, June 26, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor. I did just want to repeat the response.
Yes.
We did discuss this at the bench. I understand that at our last hearing, the court was very clear with Mr. Johnson about the fact that there was no contact with the DV victim related to this other case, and who's also involved in this case as well. And his phone privileges were revoked at the jail, and that he was having absolutely no contact with her whatsoever, including third parties. Since that time, we do have a report and transcripts from some calls apparently made with other people's pens, and he has contacted third parties. Well, he's attempted to call her 6 times, and also use third parties to make requests that they get in contact with that same victim. So tell her that he loves her. I can make a further record of some of the comments, but Mr. Johnson is apparently under the impression that because he had and still has consensual contact with her in his other case, that trumps any orders given by this court. I would ask that the court make it very clear, since in one of those calls he stated that the county, quote, fucked up his orders. And I won't repeat the comment that he made about Your Honor, apparently in this case, but I'm
sure it was very affectionate, so go ahead.
Sure. Affectionate with all the F's. So he, Mr. Johnson, is under the impression that, again, there are erroneous orders made. I would like the court to be very clear with him that no matter what order he has in any other case, a revocation of phone privileges, as well as no contact with this victim, including third parties, regardless of this location, including should he be released to inpatient treatment, as counsel's order states, all prior bond conditions remain in full force and effect. That does include contacting this victim, including with third parties. While we may not have a recording from him while he's in treatment, it will still be apparent to us because, quite frankly, Mr. Johnson has been anything but subtle since he's been having this case pending. So I'm just asking for a reminder of those conditions. And I don't have any issue with the release of treatment. However, I would ask, well, I'll just leave it at that. I'm asking the court.
Thank you. I just received the transcript of these calls, actually, just very brief, not too long ago this morning. I'm going to have a very detailed and thorough meeting with Mr. Johnson later today about his bond conditions. He does have 2 different cases. Obviously, she's not listed as a victim. In this case, it's the circuit court case where she's the victim. And so I will make it very clear with Mr. Johnson in our meeting later today. I would request the actual calls from the state instead of just the transcript.
Mr. Johnson, you understood what I ordered? Not asking whether you like it or not. You understood what I ordered?
I kind of understood, Your Honor.
What's the kinda?
I've never been in like court like this before, so I'm new to this, like being in trouble and stuff like that. So I'm not all familiar with the terms or wording and ways of effect of. I watch a lot of court TV, yes, but I don't understand personally, no. I do have like a question of like what does a no contact order mean, Your Honor? Like, if you can, like,
no contact order means that you are not to have contact with that named individual, either directly or indirectly through third parties in any way whatsoever. You are not to have contact via any electronic communication, whether it be telephone, email, social media, or anything like that. And you are also not to mention them on any social media platform. Is that clear enough for you?
Yes, Your Honor.
And understand something. I don't believe in coincidence. So if there's contact, I'm gonna believe that you purposely did it. Either yourself or through some third party. Because even after I ordered it the last time, and I don't think you don't know as much as you're trying to pretend before me that you don't know, because of some of the stuff that you were saying going out of the courtroom. Also, if true, your behavior indicates that you are sophisticated enough to get somebody else's pen to try to make communication in an indirect fashion. So you understood exactly what I said. You just didn't like it. So hopefully now you do understand. Do you?
Yes,
Do you have any other questions regarding what I mean by no contact?
no, Your Honor.
I don't want to hear any more that there is any type of use of somebody else's pen to do some direct or indirect contact with the victim, because you're not supposed to be making phone calls at all. You've lost that privilege. Anything else from either side? June 26, 2025, 9 a.m.
Your Honor, would the court consider a 1-week adjournment, or is that not enough time?
If you want, if that'll work for you. If you're trying to get I don't know about the discovery. That's the other thing I'm trying to.
Understood. Do you know?
I'll give you the 1 week.
Okay.
The 911 public problem.
June 12th, 2025,
Thank you.
9 a.m. Bond is continued with its condition and my admonition that you need to follow what I order. Thank you. Have a good day. Court calls the case, People versus DeAndre Cersei.
Hey, Richard. Oh, I'm sorry. I'm so sorry.
Evan Archer requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of APA Rachel McDuffie, Your Honor.
He was here on Tuesday.
Yes, sir.
And when he was trying to make the actual prosecutor to run out to find somebody, he was sitting there and he was doing absolutely nothing. He didn't even step up to say, can I help? And can I go out? He just did nothing. He just sat there. Remember? You do? And then I said, you go. And then he went. And you know what? He didn't even come back with the person. I don't know what he was doing out there. He just kind of sauntered back in. I don't know. But nevertheless, permission to practice is granted.
Evan Archer for the people, Your Honor.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Cersei.
Can you state your name?
DeAndre Cersei.
Thank you, sir. You're looking for an adjournment?
Yes, Your Honor, we're looking for an adjournment to continue negotiations with the people.
For the 17th or 26th? I
26.
Ow.
June 26th would be fine, Your Honor.
I knew you'd take that. And the only reason I gave Bukovich a choice, because last Thursday, I don't really feel sorry for people, really. I feel sorry for you. I really did. I mean, he was so confused. He was giving it, pointed toward the door. Just turned his back on. It's okay. I'm a forgiving person.
Thank you, Your Honor.
You don't mean that. Probable cause June 26, 2025, 9 a.m. Bond will continue. Thank you, Mr. Cersei.
Thank you.
Thank you. Court does call the case, People versus Chad Jones. That is my last one.
And Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Jones, who's approaching. Mr. Jones, can you say your name for the court?
Chad Jones.
Your Honor, there is a pattern with me this morning. I'm asking for Mr. Jones to be released to treatment. I do have a proposed order. I did discuss this with Ms. Douglas, and I don't believe she has an objection. Sorry. The issue, may I hand an order, proposed order to Ms. Douglas?
Can you? I don't know. Yeah, go ahead.
Okay. Hi. Mr. Jones does have several holds, including 2 holds that are bond denied. However, I have been in touch with his attorney in his Wayne County case, where he's going to try to get him released to treatment with a tether in the Wayne County case. And obviously, he's not going to be released from here until he deals with those 2 holds anyways. But we are trying to get the ball rolling. And I just am realizing, and I apologize, Your Honor, I did not put a tether in this order. And that is one thing that Ms. Douglas and I discussed. So I apologize. I can revise it.
And that was going to be on a GPS tether.
I don't have objection to release to treatment. If there's other, I do think that would be Mr. Jones.
I'll just insert it after available. I'll insert with GPS prior to release.
Thank you, Your Honor.
All right.
And I should have given this. I'm sorry. And I am asking for an adjournment of the PCC for continued discussion about resolution, global resolution, as Mr. Jones has multiple cases.
Yes, he does. June 17th, 2025, 9 a.m. Bond will continue. I signed the order.
Thank you, Your Honor.
Bye. Court does call the case, People versus Sterling Pierce.
Ally's on behalf of the people, Your Honor.
Good morning. Once again, Your Honor, Wendy Burnwell on behalf of Mr. Sterling Paris.
Sterling Paris, sir.
Thank you.
Your Honor, maybe you're clear.
Again? Okay. Fine. In 5. Counsel, you received a copy of that, Ms. Burke?
Yes, Judge.
And you waive any formal reading of that,
Yes, Judge.
and your plan stands to each of those charges.
That is correct. For the increasing your charge to.
All right. So taking care of that part. Also, just because of the counting of the counts, at this time, the people are moving to dismiss count 3.
Correct, Your Honor.
And there's no objection from defense. Dismiss count 3.
Don't talk to me.
And then you're requesting a forensic evaluation.
Yes, Judge, I am.
All right. Forensic evaluation is ordered. I'll set a competency hearing for August 28th, 2025, 9
If I can address bond.
a.m. Yes, go ahead.
Come to our attention, Your Honor, that the defendant has made 18 complete calls to the victim since being arraigned. In these calls, the first calls his mother wants to do a throwaway call to connect the victim in, and then eventually gets a hold of the victim. And he's telling her he loves her, he wants to get back together with her. At this time, I'm going to be asking for his phone calls to be revoked because on top of the 18 completed calls, he has 124 total attempts, including those complete calls. So at this time, I'm going to be asking that his phone privileges be revoked.
Yeah, I'd ask that not happen. I think he understands now not to make any calls. I don't want him to be cut off from his family.
Okay. Well, you request a hearing on this, but I mean, after you listen to the calls, but he's supposed to have no contact with it. That's third number,
And I've had concerns that he's calling his mom having, and that was when we called to try to get the three-way call.
which is going to be also a violation of the bond. And this time, defendant's phone privileges are hereby ordered revoked. In all other respects, his bond will continue. Thank you. I'm sorry. That was an arraignment. Pardon? Oh, that's right. Court does call the cases of the people versus Quincy Jones.
Hey, Pierre, Richard McDuffie for the people.
Morning, Your Honor. Mike Getty, Assistant Public Defender on behalf of Mr. Jones, who's here to my right, Judge. State your name, Mr. Jones.
Quincy Jones. You feel better today?
Yes, I do.
Do you?
Yes.
Sobriety is a funny thing, isn't it? Never mind, you don't have to answer that. I'll never show up here like that again. You hear me?
Yeah.
All right, what are we doing?
Yeah. Oh, I'm sorry.
Oh, I'm sorry. This was also an arraignment. The court was attempting to arraign him on the new case last time.
Right.
Yes, on the 25 F2 1293, Your Honor, or 0697, Your Honor, anticipating that that will be appointed, I would waive reading and standing.
All right. Defendant having waived formal reading standing mute, court will enter a not guilty plea as to that case. And the public defender is appointed in that matter. What date did you want me to set probable cause?
Your Honor, I did receive the police report earlier this morning. Ms. McDuffie was kind enough to send it to me. The version I got last night wouldn't open, so I haven't had a chance to go over that with Mr. Jones. I'd ask for the next available date, and if I can be heard on bond.
Yes.
Your Honor, Mr. Jones is here.
Well, hold on a second.
Oh,
I'll make it the 17th, so he's not.
Thank you, Judge.
June 17th, 2025 at 9. That's time on the other matter too. Go ahead.
Thank you, Judge. Mr. Jones is here in custody today, obviously. He does have a place to reside. He resides in Ann Arbor. He does have his own apartment. He does receive assistance from Avalon Housing. I was able to reach them on the phone, and they are, would continue to provide him assistance in navigating the ins and outs of life. He would comply with whatever drug testing the court will require, where sober link if the court, or a scram tether if the court required such. He does receive a monthly, I believe does receive a monthly shot under an ATO. I'd ask the court to give him an opportunity to have a personal recognizance bond in this matter with monitoring and whatever testing requirements that the court deems suitable.
From the people.
Your Honor, while I don't have an issue, my original request was for a $7,500 PR bond on this case. It probably goes without saying, especially at this point, that I am requesting a testing order. I don't know to what extent alcohol is something that Mr. Jones deals with, but certainly drugs, narcotics, cocaine specifically, are of concern to the people. I think that there was a request on his older file, but because he had been hospitalized and gotten out of treatment, the court declined to impose a testing order at that time. Unfortunately, I think we see that we probably need to keep close tabs on Mr. Jones's compliance. Other than that, no objection to the PR and the standard.
Yes. How often are you using when you're out?
Well, I banging not that much.
Why?
Banging not that much.
Because I was a bit surprised you did what you did last week. No, usually you show up and you show up sober enough to take care of business.
Yeah, I had there was a lot going on between my mom's girlfriend and the house selling. And it's all right. Yep. Yeah.
On case ending in 575. In that case, that I've adjourned to the 17th at 9, I'm gonna reinstate his previous bond of the 5,000 personal recognizance. All right, and the previous conditions. It means that you're gonna have testing on that, understood?
Yes, sir. Yes, Your Honor.
On his new matter, I'll set his bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. There's to be no use of alcohol, recreational marijuana, or any illegal drug. You need to repeat that?
Oh, yeah.
Sure?
Yes.
I'm going to order that he test at community corrections. How often are you testing under the old order? How many times were they calling you?
Not once.
I don't believe he was
Oh, was it?
at all.
Oh, that's right. So I'm going to order intermediate supervision with at least 2 times per week drug testing. Got that?
Okay.
Thank you.
Your Honor, will he need to report immediately to community corrections if he gets out or within 24 hours? Or will they come see him before?
Yes, they get him out, community, and you're out before 4:30. I want you getting over, or 4 o'clock. I want you getting over there to community corrections.
Yes, Your Honor.
Hear me?
Yes, Your Honor.
Thank you, Your Honor.
All right. Court does call the case People versus Paris Lester.
Camera that is on behalf of Mr. Lester is approaching.
Paris Alexander Lester.
Thank you.
Your Honor, we were going to be asking for an adjournment for a potential global resolution on his other matters.
Probable cause conference, June 17th, 2025. 9 a.m. bond continued.
Thank you, Your Honor.
Court does call the case of the People versus Jacqueline Murray.
Camera that is on behalf of Miss Murray, who can hear anything else.
Jacqueline Murray.
All right.
Your Honor, we were going to be asking for an adjournment pending for release to treatment, but I believe she's already started her Dawn Farms program in custody. So we'll just be adjourning for plea negotiations after she does some progress there.
After she shows some progress.
Yes. She just started, I believe, right?
Yes.
Is this the only, are these the only cases holding her here? Or does she have other?
She has other cases. I also believe she has cases. Well, she resolved, she has one warrant out of 35th that I don't believe has resolved yet. But here.
Okay, how much time do you want? I mean, I can do the 17th or 26th.
The 26th, Your Honor.
26th.
I think she'll have more progress at that point.
Yeah, that's what I was.
Thank you.
I guess kind of getting at. June 26, 2025. 9 a.m. bond continues.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, ma'am. You want those? Yeah. Court calls the case of the people versus Michael Patterson. Two
Morning,
cases.
Your Honor. Abigail Nice-Swanger requesting permission to go here and SCAR 8.120 under the supervision of Nora Wood.
Get that whole thing? She did? Right through the Wisconsin angles. Permission to practice is granted.
Abigail Nice-Swanger, fourth.
Mike Gaddy, Assistant Public Defender for Mr. Patterson, who's here to my right. State your name, Mr. Patterson.
Michael Lee Patterson.
All right.
Your Honor, we're here for a competency hearing. I did have an opportunity to meet with Mr. Patterson yesterday. We did go over the competency recommendation from the Forensic Center. We don't have any additions or corrections to that competency.
All right. And no other additional evidence.
No, Judge.
Is there any evidence of the people?
No, Judge.
You would stipulate to the report.
Yes, Judge.
Based upon a review of that report, court would find that the defendant is competent to stand trial, would specifically find that he can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent.
Thank you, Judge.
I'll need orders.
I will prepare an order, Judge.
Okay. And what would you like this set for?
I'd ask to set this for a probable cause, these matters for probable cause, Judge.
Are these the only cases holding him here?
Yeah.
I mean, did you want me to set it the 12th or the 17th? That's, I guess, my ultimate question.
I'll leave that to the court's discretion. I do have a request on this. Actually, I think he has an MDOC hold, Judge.
Does he? Okay.
But I think that may be cleared up. I have not been able to verify that.
All right. I'll set probable cause conference for June 17th, 2025. 9.
Yeah.
I wanted to say something to the judge.
All right, Esteban.
Yeah.
I mean, Your Honor, Mr. Patterson is here. He has indicated to me that he would like to seek treatment, most notably at perhaps the Havenwick facility in Auburn Hills. If I'd ask the court to consider if we are able to arrange that, to consider if I'm able to talk to the prosecutor, reviewing a stipulation to release to that treatment if we're able to secure it.
That would be inpatient.
Yes.
Okay. I typically am not going to have an objection to any release to inpatient treatment.
Okay, thank you.
Appropriate, but if you work with the prosecutor.
Okay. So what?
Otherwise, his bonds will continue. At
Release.
Okay.
Okay. I'll be in touch, okay?
All right.
Mhm.
Thank you, Judge.
You're welcome. Where's Miss Yagi?
I think she went back to her office.
Okay, no, that's fine. I don't know why she's doing things better than everybody else. Did that hurt your feelings, Miss Parent? No. I said she's doing something better than everybody else. And I'm just, oh, whoa. That was, wow. Okay. Oh, yeah, I know. I didn't want to repeat it.
I can't speak for everyone, but for myself, I understand why she's doing better.
Wow.
I know my limitations.
Court calls the case people versus Tyler Redmond.
That's one of the people about that.
Good morning. Attorney on behalf of Mr. Redmond. Your Honor, I had a green sheet. It was there and now it's missing. So I'll get that to you.
Probably why I said that about Yagi.
I know.
All right.
I guess I could admit my own faults.
Your name, sir?
Tyler Redmond.
Thank you.
Your Honor, we are requesting an adjournment for ongoing plea negotiations and a referral to drug courts. So we're going to
Got
get them assessed.
That's correct. That's a felony report, Your Honor.
Okay, so are you gonna be doing that referral? I mean, I'm just thinking in timing of the adjournment.
Ms. Lunny may know better than I. Do you know how long those assessments are taking?
right now I don't, but I would say if we could do two, and if it's not done, we could do a sitting order.
Yeah, that works for me.
Then why don't I just try the 17th to start with, and let's see if we can get it moving. Probable cause conference, June 7th. Bless you. June 17th, 2025. 9 a.m. Bond will continue.
Thank you.
Thank you. Thank you, sir.
It just appeared.
Wow.
I know.
No,
What
it
am I
didn't
telling-
appear. I saw her doing it. We need to start looking under everything. Don't worry about it. It's all done now.
I know.
Mr. Douche covered you. Court calls the case, People versus Lakita Roberts.
AP Richard McDuffie for the people.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender with Ms. Roberts, who's here to my right.
Yeah, Lakita Roberts.
All right.
Your Honor, in speaking with Ms. Roberts and then in speaking with Ms. McDuffie, while I would like to also discuss a global resolution, it appears that there's a bench warrant that's outstanding out of the circuit court that didn't appear in X jail that Ms. McDuffie had found. It looks like it's a 2020 FTA matter.
That was already over at circuit.
Yeah, it's just an outstanding warrant. I'd ask the court to adjourn this briefly so I can track that down and get everything all squared away.
Okay, June 17th, 2025.
Thank you, Judge.
9 a.m. Bond will.
I'll be in touch, okay?
Thank you, Mr. Roberts.
Thank you, Your Honor.
Case of People versus Aaron Washington.
AP Richard McDuffie for the people.
Pardon? Yeah. Oh, okay. What's your name, sir?
Mr. Washington.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing within on behalf of Mr. Washington. Today's the date and time set for the probable cause conference. We are respectfully requesting this matter be set for preliminary examination. We do believe all of the discovery is present.
I was just telling Mr. Brown, I didn't get a chance to tell him that I checked in advance with the OIC regarding availability. And he stated that he could be available either next week, June 10th, or July 8th. He will be out the intervening 3 Tuesdays.
Who? Yeah, I can set it.
It was just supposed to be attended hard.
Everybody's gonna be ready.
But she tried to pick up bands next to it.
Okay, so we'll work on this. So July 8th was one of the options, Your Honor.
Yes,
And what was the other?
it was June 10th. It was, yeah, this Tuesday coming up.
June 10th, please.
June 10th?
Yes, please.
Okay, everybody be ready on that day. June 10th, 2025. 9 a.m. That will be before Judge.
I don't want to.
That's before, that's before Judge Barr.
That's the next day.
I just want to check out, are we sure about June 10th?
Yes.
Okay.
Adjournment will be July 8th. We ain't trying to do that.
No, we're not German.
You want June 10th, right?
Yeah, see, that's preliminary.
You two all set?
Kind of, we're getting there.
Kinda, no,
Baby,
I ain't got all day.
Try to figure it out. Try to figure it out, Simpson.
June 10th, 9 a.m. before Judge Barr. Bond will continue. Thank you.
Thank you.
She didn't know.
Court calls case.
Recently finished.
So we had just come off of probation.
Because this happened on May 25th, Your Honor, of this year.
10 days after he's off probation. Anything else?
No, Judge. Again, it was just a relationship that went bad. He went to get some of his stuff. Alcohol didn't help. But that being said, I'm asking you to keep it 10 grand at 10%.
Well, I am going to grant the people's motion, Mr. Allen. I don't, given the circumstances, I guess the defendant has at least shown while he's been out at this point that he's able to conduct himself appropriately. So I'm taking that into consideration. But I think that the initial setting of the bond in this case was an abuse of discretion given the circumstances. I will set the defendant and the fact that the defendant just got off probationary status 10 days prior to this, which again, I don't quite get why he would get himself potentially involved in something like this. I will set the defendant's bond at $20,000. I'm not going to make it a cash or surety. I'm going to give him 10% privilege on that if it can be posted. So it's $20,000, 10%. At this point, all other conditions remain in effect.
Thank you, Judge. Can we adjourn this matter to the 26th? I was just retained last night, and I imagine there's a lot of discovery.
Probable cause conference will be adjourned June 26, 2025. 9 a.m. or as your invite indicates. Thank you. Court calls case People versus Emily Ann Bates.
But I want to be on behalf of Ms. Bates.
Andrew Childers, appearing on behalf of people.
I don't know if she's present, Your Honor. Hope she is.
And that springs eternal.
Wishful thinking. You know, I know Ms. Bates has had many probable cause conferences. She has been present for, I believe, all of them. I don't have an explanation for her failure to appear. Again, she's usually here. I was not able to get in contact with her this week.
Bench warrant will issue for defendant's failure to appear. Bond will be set in amount of $10,000 cash surety. That warrant will issue immediately. Court calls case People versus David Leland.
And Assistant Public Defender, Shanazi Kyriakin, Your Honor, on behalf of Mr. David Leland.
I figured out the conversations are your fault.
It is,
Just the moment somebody sat down next to you, start talking again.
It's me.
Not that I'm paying attention.
Mr. Leland, state your name for the record, please.
David Duncan Leland.
Thank you, sir.
And Judge, we are requesting an adjournment of the probable cause conference. We are still, we just signed the protective order, so we're waiting on additional.
That's correct, Your Honor. I just submitted the second order to the court earlier today.
Got it. Okay. 26, will that work?
That will work fine.
June 26, 2025, 9 a.m. or as your invite indicates, bond will continue.
June 26th.
Thank you, sir.
Thank you, sir.
Court calls case People versus Timothy Lloyd. Second release, is that the green sheet?
That is.
Michael Gaddy, Assistant Public Defender for Mr. Lloyd.
Your name, sir?
Timothy Lloyd.
Thank you. Wait, what are we doing?
Your Honor, we'd ask the court to set this for a preliminary exam.
All discoveries complete.
Best of my knowledge, Judge.
People have their witnesses available the 17th.
A request, not that we are not going to be, in the office, to go one more week out. if possible.
Any objection to that?
Leave it to the court's discretion.
Preliminary examination in person will be set June 24th, 2025, 9 a.m. That will be before Judge. I'm sorry? Judge Fleischer.
Thank you, Your Honor.
Bond will. I'll be in touch, okay? Court calls case People versus Derek Martin.
Good afternoon, Your Honor. Student Attorney Kara Rosengren, under the supervision of APD Stephanie Hannon, on behalf of Mr. Martin. Mr. Martin, can you state your name for the court, please?
Derek Charles Martin.
All right, what are we doing?
Your Honor, we're going to be asking to adjourn as we're still awaiting some further discovery and to further plea negotiations.
What discovery is outstanding? That was a question.
My apologies, Your Honor, what was the question? I'm so sorry.
What further discovery are you waiting?
Your Honor, Stephanie Hannon, was in on behalf of Mr. Martin. When I was going through, the discovery that we did have, it did look to me like there was some video evidence missing. And I can't remember if this is one of the ones I've emailed on already. I know there were a couple, and I will email and get that happening.
Probable cause conference will be adjourned June 17th, 2025. 9 a.m. Whereas your invite indicates. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Robert Martin.
Evan R. Terry requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of APA Rachel McDuffie, Your Honor.
That?
I did, Your Honor. I was told to do it again.
From who?
Who
told you before me you had to do it again?
I told him he should ask. If he has to. Any options?
That's not even true. Why would you tell him to ask?
Because he had a question. You should ask him.
Every,
Assistant Public Defender.
I want to almost deny it just cause. Fine, permission to practice as granted again.
Evan R. Terry, 50.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Martin. Mr. Martin, can you please state your name for the record?
Robert Martin.
At this time, Your Honor, we're requesting a brief, approximately a 3-week adjournment to allow Mr. Martin to go obtain a substance abuse assessment in hopes of achieving an offer.
Got it. Probable cause conference and will be adjourned June 26, 2025, 9 a.m. Whereas your invite indicates. Bond will continue.
Thank you, Your Honor.
Thank you, sir. Thank you.
Thank you, Your Honor.
Court does call the case of the People versus Jermaine Mazza.
That was the people?
Assistant Public Defender Natalie Pay on behalf of Mr. Mazza, who may be present via Zoom.
Yeah, we do. Hello.
Your Honor, I'm grabbing him now. This is
Okay.
social worker at the hospital. We're just getting the door open, Your Honor.
Mr. Mazza?
Hello,
Hello, state your name, please, sir.
Jeremy Mesa.
Okay.
Thank you, Your Honor. I'm respectfully requesting an adjournment. I have had discussions with the people regarding this case, and I believe they have reached out to the officer in charge regarding a potential resolution. Mr. Meza is also currently hospitalized at Trinity Health and then expects to be released to treatment at Bear River when he is done at Trinity Health. The court and the people should be in receipt of that documentation from Trinity Health. So I'm asking for an adjournment if the court would consider around 3 weeks.
Yeah. Okay. Any objection from the people? Probable cause conference, June 26, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. All right. Thank you, Mr. Mesa. Good luck to you.
Thank you. Here, I don't know how you.
Court does call the case of the people versus Lanish Mitchell.
Student Attorney Kara Rosengren, under the supervision of APD Stephanie Cannon, on behalf of Ms. Mitchell, could you state your name for the court?
Lanish Mitchell.
Do you feel a need to like ask permission again?
Well, I only thought I had to do it at the top of the
At
day,
one,
sir.
right?
Yeah,
Yeah, so you were told that.
yes,
Your supervising attorney told you that. Because they knew, right?
yes.
Yeah. I wonder why that doesn't occur over here. All right, anyway, go ahead. Just thought I'd ask.
Your Honor. Thank you, Your Honor. We are going to be asking to hear in this matter for discovery and further plea negotiations.
What other discovery you think is still pending?
Your Honor, and I'm doing emails right now into that. Your Honor, at this point, we are missing video discovery on this. Any and all photos collected at the scene.
But you're sending an email to try to get that rectified, whatever you think is missing.
Yes, yes.
She's making her intern do the hard work. June 17th, 2025, 9 a.m. That's a Tuesday. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Samuel Peoples.
Hey, Rachel McDuffie requesting permission to correct. No, I'm sorry.
Denied. Oh, you don't want to give that opening to me, Miss Duffy.
Student Attorney Kara Rosengren, under the supervision of APD Stephanie Cannon, on behalf of Mr. Peoples. Your Honor,
You have no client.
Your Honor, yes, I have, we are requesting to adjourn, and I also have a letter from Trinity Health Hospital in Ann Arbor where Mr. Peoples is currently hospitalized.
No objection to the adjournment. I did want to advise the court and counsel. Somehow I have 7 unreviewed warrants for Mr. Peoples, and 4 of those just came in yesterday.
That sounds like a prosecutor's office. No, go ahead. What?
Some of those might be duplicates. It appears that Mr. Peoples, when he was arrested on this count, made admissions to some of the other offenses that he knew that he was going to be accused of, because I did see some duplicate report content. So I will go through all of those and figure out what needs to be charged and what does not, but I just wanted to make everyone aware.
Oscar. We don't have a. He's gonna remain until medically cleared. All right. Or maybe give you time to do all those warrants. I'll adjourn this out to the 26th. 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case People versus Taiwan Phelan.
And with others on behalf of Mr. Phelan. Your Honor, we are asking hopefully for one last adjournment, so we are able to continue plea negotiations with the prosecutor's office.
Probable cause conference will be adjourned June 17th, 2025, 9 a.m. bond continue.
Thank you.
All right, that's a Tuesday. Court does call the case of the people versus Kirby Snyder.
Appearing on behalf of the people.
Good afternoon, Your Honor. Intern Malika Fatima appearing on behalf of Kirby Snyder.
So they actually let you do another case?
Yes, Your Honor.
He only gave you two things to do? Don't look at him, answer me. Is that what he did?
Yes, Your Honor.
So he's not treating you right, is he?
No, he's treating me amazing.
We're looking for some evidence to go against Brown. All right. All right, go ahead. What are we doing?
Your Honor, we are requesting a 1-week adjournment as Ms. Snyder had to go to urgent care today.
Do we have any medical documentation?
Yes, we do.
Oh, he has it, like he's saving the day. Have you seen that, Mr.?
I have.
Oh. We can go ahead. Okay. Well, what I'll do is I'll put it out to the 17th. Probable cause will be adjourned June 17th, 2025. 9 a.m. bond will continue.
Thank you, Your Honor.
All right. He only did one other case and then he had half the information. Court calls the case people versus Matthew Vermaelen.
Alexander, on behalf of the people, Your Honor.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Vermeulen. Say your name for the record, please.
Matthew Vermaelen.
I have two things for you. I do have a green sheet. We are requesting an adjournment of the PCC. There is outstanding discovery. It's a 911 call we're waiting on. I have spoken with Ms. Zenda and it is on its way. We just have not received it yet.
Filed yesterday, so it should be to their office in the next day or two.
And the second, I'm taking a page out of Ms. Yagi's book, is a stipulation.
Yagi's book?
Didn't she get you an order?
Okay, so.
I thought that's what the compliment
Oh,
was
yeah,
for.
okay, yes, she did. I gave her a compliment that she was doing better than the rest. You acted like I shouldn't have said that to another woman or something. I mean, I don't know what, you just got an attitude.
No, I was happy that you
No,
said it.
you
I was
got
happy.
happy later. Your initial response was not that.
No, my shock was out of pleasure for her.
Alan, was that how she?
Don't you think? Well, Your Honor.
We got the video. I'll go back and play that anyway.
We have agreed to cease testing requirements on this case.
Yes, I see that, and I've signed that order.
Okay.
Parties agree to that.
If I could also address bond.
Oh,
Yes.
yeah. Lots of things.
I believe last time we were here, the no contact order was removed. However, we've heard back from the victim and she's asking for it to be put back into place because after it was removed, she said the defendant tried to guilt trip her and make her feel bad about this whole case and told her to lock the windows at night in her house because that's how he got in. I have concerns, and she told him to stop contacting her and he did, which we are appreciative of, but at this time I would be asking that the no contact order be put back into place on this case.
Your Honor, I don't think that's how we would characterize any of those conversations. However, we have no objection to the no contact order being reinstated.
We will reinstate the no contact Was there a no go to with that or?
I believe that was kept in place, Your Honor. For her adjournment.
So the no go to was always kept in place. It was just a no contact.
Correct.
Got it. Okay. I've signed that order. And how much time did you?
I think it's, as Ms. Linda said, it's on its way. It should be here in the next couple of days. And then just need to review it with my client. So I think the shortest.
Set June 17th, 2025. Any bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Roman Whitfield.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Roman Whitfield, who should be present via Zoom. Sir, can you please turn on your camera, unmute, and state your name for the court?
Where's one? That might be him. Mr. Whitfield? Oh, that might be. Is that him?
Yeah. Mr. Whitfield, can you state your name for the court?
Roman Whitfield.
All right. Yeah. Okay.
Thank you, Your Honor. The court should be in receipt of a signed waiver form that Mr. Whitfield gave me permission to sign on his behalf. He will be waiving his right to preliminary examination today.
I don't have it yet, but that's okay. Mr. Whitfield, is that correct, that you're waiving your right to a preliminary exam?
Yes, sir. Yes, sir.
All right. You understand that that's a proceeding where the people have to show by probable cause that the offense, that those offenses were alleged, that the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendants bound over on both counts.
Thank you, Your Honor. We would waive any further formal readings. My client stands mute and asks for a pretrial date in circuit court.
Having waived formal reading, standing mute as to both counts, court will enter a not guilty plea. Pretrial will be set for
July 30th at 1:30 would just come.
July 30th, 2025, 1:30, Judge Conlon. Bond will continue. Thank you. Thank you, Mr. Whitfield.
Thank you, Your Honor.
Yes, sir. Have a blessed day.
Thank you, Mr. Whitfield.
Yes, ma'am. Have a blessed day.
You too.
Court does call the case of the people of the state of Michigan versus Taylor Adams.
Nationality for the people.
It's an arraignment.
It's not, Your Honor.
Your name, sir?
Taylor Adams.
All right. We are set for PCC. And where are we on this case?
My attorney is not here. He's sick, but he has the acceptance. So I was told to file for.
Who's your attorney?
Nunzio.
Who?
Damian Nunzio. 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 He has his acceptance. I told the one lady that came up to me earlier today that he was not here, and she said, okay. So, yep.
Yeah. Oh, you're that one lady?
Yes. Sorry. Sorry.
That's okay.
So I'm looking now, it doesn't look like JS has updated yet with an appearance from his.
It is, or it is not?
Said that he could call to show the acceptance. I don't know.
You want me to call him?
We could.
I'm a little busy.
I won't know. I mean, whatever I need to do to let everyone know that he's supposed to be here. He was sick for the last 3 days.
Do you have any objections to me adjourning it out to the 17th?
I don't, Your Honor. I'm trying to see in my notes if I have any concerns that I want to bring up today, but I think that should be fine. Yeah, go to that.
Okay, tell your attorney a couple things. First of all, that we need an appearance, what's called an appearance from him. Okay. And then the second thing is that I'm adjourning your probable cause conference to June 17th. That's a Tuesday, 2025, 9 a.m. It'd be 9 a.m., but if he gets his appearance in, he'll get the time block that he's in.
Okay.
And can communicate that to you. Bond will continue.
Thank
All
you,
right,
sir.
thank you, sir.
Thank you, guys.
Where'd Perrini go? What? She's going to talk to Yaki. Okay, all right, well, I won't worry about it. So, young man, how many times do I request that you ask permission per docket?
One time.
Got it?
Got it.
All right, he's a quick learner. All right. She knew that. Didn't you? You knew that. I'm still trying to figure out why you didn't know. We all know it's the one standing right there. All right, court is standing recess. All right.
Okay, Mr. Thompson, do you have Ms. Danko present?
She is here, Your Honor. She asked for a few more minutes to confer with me. We wanted to make sure we were here with the court here. If I could have a few more minutes, I'd appreciate it. Thank you.
We're off to a fine start. Sure, what the whole point of that was.
Judge Burmeister requires them to be in the courtroom.
Doing some things to help her own cause that haven't occurred yet, but that she would intend to have occurred.
Like, I just want to know what's going to change between now and 30 days. That's all.
I think there's a possibility the plea could even improve some more.
So is that correct?
I don't, this case has been going on way too long, Your Honor. I guess I won't object if the court wants to adjourn it out a couple of weeks, but after that, the plea offer is pulled, and I'm not going to continue going down this road with her. We'll set it for trial at that point.
Just on 421, the plea offer was an attempt to count one in the withdrawal.
And that's still the offer.
And that's the offer, that is the offer I referred to receiving recently. I guess we did put it on the record on 421. As I said, we had been discussing it for some time, so I don't want to represent that it's exceptionally new. But.
Yeah, so, I mean, so we adjourned this on April 21st.
Correct.
We did, Your Honor.
Okay, so Ms. Danko, I mean, that was almost 2 months ago. If you're gonna enter a plea, it needs to happen today, so if you want to talk to Mr. Thompson a little bit more, but I'm not gonna keep delaying this for really no reason. And you don't have to accept the plea agreement, that's up to you. I'm not trying to tell you you have to do that, but what I'm saying is you have to make a decision today. You got plenty of time to consider this. You know what the plea offer was on April 21st, it hasn't changed. It doesn't sound like it's going to change over the next 30 days. That's 6 weeks.
I was told it will change.
Doesn't sound like it. You know what it is, you've known what it's been for 6 weeks at least. Give you more time here this morning if you want to talk to Mr. Thompson. But if we don't go forward with the plea today, the court's going to set it for trial, and I will not accept any pleas after today. Want more time to talk to Mr. Thompson? What do you want to do? So we'll set this matter for a jury trial. And Mr. Thompson, I mean, since we're having this discussion, I just want to make sure the record is absolutely clear. Morning of trial, night before trial, week before trial, the court will not accept any pleas after today. So this is the final decision. What the reason is after courts. A lot of times the court is a little more liberal in accepting things late, but because we're having this conversation today, I will not be. Ms. Coke, how much time do you need to be ready for trial in this case?
Your Honor, we can be prepared in 30 days. I'm not sure that we can get it done in one day. Usually I'm able to try one day, but these are pretty significant charges. It's a habitual third. And there's going to be a lot of technical testimony. I think I can do it in one day, but if the defense has witnesses, we should set it for 2.
This seems like a 2-day trial to me, Your Honor. It's very fact intensive. This isn't like a possession case.
Mr. Thompson, how much time do you want before the court sets this for trial?
I would ask for 60 days, Your Honor.
Ms. Coke, are you anticipating any pretrial motions?
No, I don't think so. I mean, defendant confessed to the case. I don't see any reason to do any pretrial motions.
Mr. Thompson, are you anticipating any pretrial motions?
Not this time, no.
So the court is not going to set a final status conference or plea cutoff. Since I'm treating today as that. I will set the motion cutoff though 30 days prior to the trial date. So to the extent that parties do have any motions to be filed, that would be the final.
That's the final date, Your Honor, just so I'm clear.
Filed and heard later.
Okay.
30 days from there. And I'll send out a scheduling order. Ms. Coke, anything else that we need to address in this case today?
No.
Your Honor, my client's asking if I could confer with Your Honor and the prosecutor off the record briefly. Thank you.
I'm going to take, we have a 9:30, so we'll take that 9:30 hearing.
Certainly.
Do you know if Ms. Sheldon's going to be here? That's a district court. Yes, she's right here. Okay.
Prosecutor on this case here as well.
Okay. versus Andrea Sheldon. Sheldon, right up to the podium, please. Thank you. This is District Court case number 2517994. I'm presiding over this file by assignment. If I can have counsel with your parents.
Wilson Broad, Special Prosecutor, Your Honor.
Thank you, Your Honor. Jason Thompson, attorney for Andrea Dunphy Sheldon.
This is set for a status conference today. Mr. Thompson, tell me where this file is at.
Yes, Your Honor. There's a plea offer in this matter to plead to a deferral. Discussed that with Ms. Sheldon. She's indicating she wishes to reject that offer, exercise her right to a trial. She didn't want the court to address her bond conditions. There is a bond condition prohibiting contact with the alleged victim in this case. In this case, the alleged events happened February 7th, 2025 for reasons. Nothing was charged until late April. In the meantime, the parties have been residing together. There haven't been any problems. They both made their statements to law enforcement. I don't believe there's any public safety or administration of justice concerns that would justify displacing her from the home, separating the parents of the minor child they share together. They do have a statement from the alleged victim asking that no contact order be dropped as well.
Okay. Got a chance to see that, Mr. President?
It's just handed to me, Your Honor, so no, I haven't, but I'll read it. The court will give me a moment.
Sure. Just a second.
I don't believe that gentleman, Mr. Josh Sheldon, is here today, but he stopped by my office yesterday and dropped that off. And Your Honor, in terms of the allegations in this case or the offer of proof, I mean, they're very minimal. There's an allegation that Ms. Dunkley sprayed some sort of cleaning product in the direction of her former husband while they were having an argument about cleaning things.
Mr. Brown?
Well, I think the allegation is that Ms. Sheldon sprayed OxyClean in her husband's face and got into his eyes, and his eyes were burning, according to him at the time. At the time, I think the defendant denied that, but regardless, I guess with regard to the no contact provision, those are things that I think policy is to leave in place as long as these sorts of cases remain pending, absent some change in circumstance. The delay in charging was basically because a special prosecutor was required, and that takes some time to process through. For no fault of my own, but certainly there's a process for that, and it does take probably too much time, but that is what it is. Regardless, I guess with respect to the no contact, I'll leave it to the court's discretion. This was not violent in the sense of throwing punches or putting hands on people. It was, but nonetheless, it's still an assault. So I'll leave it to the court's discretion.
I do know that Dr. Sheldon has approached Grace Center about the family counseling. She would ask the court to consider, that it would be beneficial for both her and the alleged victim to undergo that kind of counseling together. That would necessitate contact. Thank you.
In terms of scheduling the trial, Mr. Brott, do you have any timeframes that we need to accommodate? As a special prosecutor here, I know there may be some different considerations.
Not that I'm aware of, I guess, as far as I think this is probably most district court matters, I think like this, we could probably get done in half a day or a day at most. So I don't, and there's, without knowing what dates the court's considering, I don't really have any other input as to that at the moment.
Okay, so as soon as the court get a date scheduled, which likely is going to be probably 30, at least 30 to 60 days.
That should be fine, Your Honor. And if there's an issue with a particular date that gets set, I'll certainly notify the court immediately.
Okay. Mr. Thompson, in terms of being ready for trial in this case.
Yeah, we're ready today, and I would concur. We could probably have this done by 1:30, one-day trial.
Okay, so the court will set up for a one-day jury trial at the court's next available date, so we'll get it on the docket as quickly as we can. With a short trial like this, get it on the docket quickly. So in terms of the bond conditions, in domestic violence cases in particular, no contact is an important bond condition for a variety of reasons, not necessarily just for the safety of the person who is the alleged victim. Particularly because this case is going to be going to trial, and because Mr. Sheldon is the complaining witness in this case, I don't think it would be appropriate to lift that no contact, because you're going to be adversarial parties in the trial. To have you living under the same roof gives the court concerns for the integrity of testimony at any trial if there is contact between now and then. So for those reasons, and given the nature of the case, the court is not going to modify the bond at this time. But again, understanding that the parties share a child, that do wish to engage in counseling, which of course I think is a good idea, but I think this needs to be resolved before we move forward with those kind of things. So the court will get it scheduled as quickly as it can. Mr. Brad, anything further that we need to?
No, Your Honor. Thank you.
Nothing further for today's record, Your Honor.
All right. Did you want this letter back, or did you?
Yeah.
Want the letter back? Thank you. All right. Thank you. That's all for today.
Thank you, Your Honor.
Mr. Thompson, do you know if you're handling Mr. Kinsler's matter? That's Mr.
I was.
Fleischer's case. Okay, he's available. Sir Kinsler, are you able to hear me okay?
Yes, sir.
We're on the record now in People versus Jonathan Kinsler, file number 225113. The record should reflect that Mr. Kinsler is appearing by video today by prior approval of the court. If I could have the counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Jonathan Kinsler.
And Mr. Thompson, you have not been appointed yet.
Correct. This is an arraignment. My understanding is there's an issue with payments. The claimants, they haven't been made.
Got it. So Mr. Kinsler, you're before the court today on a technical probation violation, and the allegation is that you failed to make any payments towards your court-ordered fines and costs, which is a requirement of your probation. First violation.
Yes, Your Honor.
So, Mr. Kinsler, the maximum penalty that you could face for this violation would be up to 15 days in jail. You do have the right to have a hearing as to whether or not you did violate your probation as alleged. You also have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. Mr. Thompson is here to represent you today, and to the extent that you need to consult with him, I would certainly give you time to do that today if you needed to. Do you understand all those things that I've stated to you?
Yes, sir, I do.
Okay. Mr. Thompson, did you have a chance to talk to Mr. Kinsler?
I have not yet spoken to Mr. Kinsler.
Did you want to be able to do that?
I had talked to the probation officer, and I believe there was consideration of perhaps adjourning this out to allow those payments to occur. I would be agreeable with that before consulting with them.
Okay, Mr. Haven.
Yeah, I would not object to an adjournment. I'm not sure of his employment status. The latest I see, he lives in Oakland County and is supervised there. So last case note, I saw that he had applied for some VA disability. So I don't know if he's currently working. I know he had been. We've extended his probation once already. So if he has any source of income, yeah, I would like to see some payments and maybe adjourn 60 days to see if that can happen.
Okay. Have you been able to talk to Mr. Kinsler?
I haven't talked to him.
Okay. Mr. Kinsler, do you have Mr. Haven's contact information?
So yeah, I believe in the court summons that I got through email. I believe there's contact information in that, but I'm not 100% sure. If you could give me his information today, I can contact him by phone.
Okay, Mr. Haven, can you do that?
Okay, you got something to write with?
Give me 1 second. Okay, I'm ready.
Okay, my phone number is 989. 344.
Okay.
3251.
Okay.
All right, so Mr. Kinsler, what I'm going to do for purposes of today's hearing is I'm going to enter a not guilty plea on your behalf. I'm going to set this as a PR bond, so you don't have to post any money, but the conditions of that bond will be the conditions of your probation.
Yes, sir.
And then I'm going to set this for a hearing in about 60 days. I'm going to ask you to get in touch with Mr. Haven this afternoon and talk to him about what we can do to resolve this issue, okay?
Yes, sir. Sounds good. I appreciate it.
All right, Mr. Haven, is there anything else we need to address today?
Nothing further, Your Honor.
Mr. Thompson?
Nothing further, thank you.
Mr. Kinsler, do you have any questions at all?
No, sir.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
All right. Thank you, sir. Y'all have a good day.
Thank you. And Mr. Thompson, in this code, if you want. Thank you.
I don't know how to disconnect this, and I think they can hear me in the court, so.